Good morning, everyone. We're going to go ahead and get started. I'm going to call the Nevada Commissions on Ethics meeting to order. First item of business will be the roll call and then the pledge. Roll call, Chair Wallen here. Oh, and for my commissioners, please press your mic after I call your name. Vice Chair Dufferin, he is excused. Commissioner Grunwald? Here. Commissioner Lowry?
Here.
Commissioner Moran?
Here.
Commissioner Olson?
Here.
Commissioner Towler?
Here.
And Commissioner Yen.
Here.
Great. For staff, we have Executive Director Armstrong,
Here.
Associate Counsel Bassett,
Here.
Investigator Terry, Senior Legal Researcher Pfaff, Executive Assistant Pedroza, and then we have Deputy Attorney General St. Jules,
Here.
and Conflict Commission Counsel Klump.
Here.
All right, please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Next item, item 2, public comment. I would like to ask the Executive Director whether the Commission received any public comment by email to be read into the record, and if there are any members of the public here.
Thank you, Madam Chair. This is Executive Director Armstrong. We did receive some public comment prior to our June meeting where this matter was scheduled for, and so those were included in the materials last month, and they're also included in this month because they were related to the matter. One of the matters we'll be hearing today. There are members of the public here in the room in Carson City. They indicate they're just here to observe and no public comment. We've received no other emailed public comment other than the ones that were the repeat from last time or that are otherwise in your packet. I would ask, I don't know if BPS can show the room to see if there's anyone in Las Vegas, but in Carson we just have public here to observe, not to comment.
Executive Director, or Assistant Pedroza, do we have any members online on the telephone that wish to comment?
I'm not sure. We have to ask the housekeeping production.
Okay. BPS, are there any members of the public wishing to comment on the line, on telephone?
Thank you, Chair. There are no callers to provide public comment at this time.
All right, then we will proceed. Next item of business, item 3, approval of the June 13th, 2023 Commission minutes. Commissioners Moran, Olson, and Yen did not attend the June 13th meeting and may not participate in the approval of the minutes. All other commissioners may participate. Are there any additions or corrections to the minutes as read? Hearing none, I'll entertain a motion to approve the minutes as read.
I motion to approve the minutes.
Is there a second?
I second.
Commissioner Greenwald seconded. Next item, item 4, we'd like to welcome. Oh, sorry. All those in favor say aye.
Aye.
Aye. Opposed? Motion carries. Next item, item 4, welcome and introduction of our newest commissioners, John T. Moran III and Stan R. Olson. I would like to welcome them. Commissioner Moran was appointed originally earlier in the year, and then he was appointed on June 6th to start serving, filling out the remaining term for Commissioner Sheets. And then Commissioner Olson was appointed on June 11th to replace Commissioner Oscarson's position on the commission, whose term ended June 30th. So welcome, and we are looking forward to working with you and having you on the commission. And I hope you're ready to work really hard because we do a lot of work on this commission. So thank you. Welcome. All right. Next item is item 5, hearing on deposit of motions and consolidated case numbers 21-062C and 21-082C regarding Joseph M. Lombardo, Sheriff of Clark County, State of Nevada, including providing authority to the chair of the commission to prepare and issue the order reflecting the commission's decision and other matters relating thereto, in consultation with the conflict counsel for the commission. I would like to note proper notice has been provided and waivers have been received for consolidated ethics case numbers 22-062C and 22-082C Lombardo. The members of the review panel, Vice Chair Dufferin and Commissioner Greenwald, may not participate in the consideration of these depositive motions pursuant to NRS 281A-2204. All other commissioners may participate and vote on this matter. At this time, I would like to ask if there are any disclosures or abstentions to be made. Commissioner Moran.
Yes, Madam Chair, thank you. Membership, also parties present, John T. Moran, Member, Ethics Commission. I herewith make disclosures in consolidated case numbers 21-062C and 21-082C. I am an acquaintance of former Sheriff Lombardo and now Governor Lombardo. I have known Governor Lombardo in a professional or public capacity for a number of years, although none of my work directly involved him, either formerly as sheriff or presently as governor. I would categorize our current relationship as professional acquaintances rather than a personal friendship. Additionally, Governor Lombardo appointed me to sit as a commissioner on the Nevada Commission on Ethics with a term to start October 1st of 2023. Upon the unexpected resignation of a commissioner whom I was scheduled to replace upon the expiration of term, my start date as commissioner was reset to July 1, 2023 to fulfill the remaining term caused by the resignation. Under NRS 281A-065, my relationship with Governor Lombardo is not within the definition of a commitment in a private capacity to the interests of another person. Consequently, the relationship does not require disclosure or abstention under the ethics law pursuant to NRS 281A-420. Additionally, nothing in Judicial Canon 2.11, the Code of Judicial Conduct, requires disclosure or abstention pursuant to the manner of my appointment. In fact, Nevada law favors the right of a public officer to perform the duties for which the public officer was appointed to vote or otherwise act upon a matter. However, in my capacity as a commissioner, I serve in a quasi-judicial role and desire to alleviate any concerns of impartiality. Consequently, I am disclosing the extent of these relationships. Further, I have reviewed Judicial Canon 2.11 of the Code of Judicial Conduct, which lists the types of relationships and events that require disqualification, and have confirmed that the presented circumstances do not qualify as a disqualification or require a disqualification. Moreover, I believe I will be fair and impartial in considering this matter and have no actual or perceived bias. I don't believe my acquaintanceship with Governor Lombardo or my appointment to the Commission on Ethics by the Governor Lombardo, would materially affect my independence of judgment or that of a reasonable person in my situation. Therefore, I will be participating in voting on this matter. Thank you, Madam Chair.
Thank you, Commissioner Moran. Are there any other disclosures and/or abstentions? Commissioner Olson.
I'm making this disclosure in consolidated case numbers 21-062C and 21-082C. I'm a former co-worker of the former Sheriff Joseph Lombardo, having worked at Metro at the same time.
Hold on.
What'd I do? Not. That better?
Yes, thank you.
You want me to start over? Yes, Chair? Okay. I'm making this disclosure in consolidated case numbers 21-062C and 21-082C. I'm a former co-worker of former Sheriff Joseph Lombardo, having worked at Metro at the same time. Although I am aware of who Joseph Lombardo was, I never worked with him. We never worked together. I retired from Metro in 2007. I would categorize our current relationship as former co-workers and professional acquaintances. Additionally, Governor Lombardo appointed me to sit as a commissioner on the Nevada Commission on Ethics with a term starting July 1, 2023, to fill the vacancy caused by the expiration of the term of Commissioner Oscarson. My understanding is that my appointment was made pursuant to statute and in the ordinary course. Finally, I registered as a lobbyist during the 2023 legislative session in the Nevada Legislature. Since the conclusion of the 2023 legislative session, I have not communicated directly with a state legislator or member of a local legislative body on anyone's behalf. I have no future plans to do so. Under NRS 281A-065, my relationship with Governor Lombardo is not within the definition of a commitment in a private capacity or an interest of another person. Consequently, the relationship does not require the disclosure or abstention, under the ethics law to NRS 281A-420. Additionally, nothing in the judicial canon 2.11 of the Code of Judicial Conduct requires disclosure or abstention pursuant to the manner of my appointment. In fact, Nevada law favors the right of a public officer to perform the duties for which the public officer was appointed and to vote or otherwise act upon a matter. However, in my capacity as a commissioner, I serve in a quasi-judicial role and desire to alleviate any concerns of impartiality. Consequently, I am disclosing the extent of these relationships, and further, I have reviewed Judicial Canon 2.11 of the Code of Ethics Conduct, which lists the type of relationships and the events that require disqualification, and have confirmed that the presented circumstances do not require disqualification. Moreover, I believe that I will be fair and impartial in considering this matter and have no actual or perceived bias. Having been a former co-worker of now Governor Lombardo, or my appointment as a commissioner on the Commission of Ethics by Governor Lombardo will not materially affect my independence of judgment or that of a reasonable person in my situation. Therefore, I will be participating and voting on this matter.
Thank you, Commissioner Olson. All right, now we'll get ready to start the hearing, all right? First item that we want to address is the request for judicial notice. Before me as chair of the Nevada Commission on Ethics is a request for judicial notice filed by counsel for the subject, as well as an objection to an exhibit attached to Lombardo's motion for summary judgment. The request for judicial notice requests that the commission consider an article and still photograph attached to the request. The executive director requests that the commission not consider an email from Ms. Bassett to Mr. Merkovich during settlement discussions. I first note that the motions filed by both the subject and executive director contain numerous exhibits, including news articles, campaign accounting statements, etc. Neither party requested that the commission take notice of those documents. Pursuant to Nevada Administrative Code 281.A.465, the rules of evidence may be relaxed at the discretion of the commission chair. I find that the documents attached to the motion briefing are subject to admission for consideration pursuant to NRS 47.130 because they are either facts generally known or which are capable of accurate and ready determination by sources whose accuracy cannot reasonably be questioned. Further, the subject article of the request for judicial notice has been submitted for the purpose of indicating what exists in the public realm at the time, and I admit Exhibits 1 and 2 attached to the request. Finally, the settlement communication attached to Lombardo's motion for summary judgment is admitted because NRS 48.1051 governing admissibility of settlement communication only excludes such communications to prove liability or invalidity of the claim or its amount. The statute does not require exclusion when the evidence is offered for another purpose. In this instance, it appears that Lombardo's counsel attached the email in an effort to address the arguments he believes the executive director might make in a motion for summary judgment, not to prove the invalidity of the complaint against him. Therefore, the communication attached as Exhibit 37 to Lombardo's motion for summary judgment is admitted for that purpose, and the executive director's objection is overruled. All right, I want to make a note here. All deliberations will be done in a closed session, okay, for my fellow commissioners. At this time, I would like to ask the counsel for the parties to identify themselves and their clients for the record.
Good morning, I'm Elizabeth Bassett. I'm the Commission's Associate Counsel, and I represent the Executive Director.
Thank you.
Good morning, Chair Wall.
Yes.
I'm not sure if it's appropriate to stand or not. I'm used to getting in front of courts and always standing, but if it's okay to sit, I'll continue to do that, so I'm not doing something abnormal.
Whatever's comfortable for you, as long as we can hear you on the microphone.
Okay, great. Well, good morning, Chair Wall and fellow commissioners. My name is Colby Williams from the law firm Campbell & Williams. I represent Governor Lombardo in this proceeding, and with me, because they don't have a mic, I'll go ahead and introduce my colleagues, Samuel Merkovich, Philip Irwin, and Donald J. Campbell, all from my law firm, Campbell & Williams. Thank you.
All right. Thank you very much. At this time, I would like to go and ask Ms. Bassett to present any initial, or let me go over how we're going to do this today first. So we have two dispositive motions for the commission's consideration. For presentation purposes, Ms. Bassett will first present argument on the executive director's motion for summary judgment. Second, Mr. Williams will present the argument on Mr. Lombardo's motion for summary judgment and may present counter-arguments to the executive director's motion for summary judgment. Third, Ms. Bassett will present argument on the executive director's opposition to Mr. Lombardo's motion for summary judgment and any final remarks. And fourth, counsel for Mr. Lombardo will present final arguments. So at this time, I'd like to ask Ms. Bassett to present any initial arguments on the executive director's motion for summary judgment.
Thank you, Chair Wallen. I have an initial matter, however, that I'd like to address. At 9:05, as we were sitting here getting ready to have this hearing, I received a PowerPoint that I understand my opposing counsel intends to use as a exhibit during their argument. That's the first time that we have seen that exhibit. I understand that we don't have specific deadlines in our scheduling order for the exchange of exhibits of that type. However, I believe that a reasonable standard would apply in any case, and 55 minutes before argument, I don't believe, falls within the reasonable standard. So I would request that opposing counsel be precluded from using that PowerPoint.
Mr. Williams, can you please comment?
Sure. First of all, the PowerPoint is a demonstrative presentation. I would ask that it be marked as hearing exhibit 1 or A. However, the commission would like to denominate it. But this is simply going to reflect our talking points in terms of the presentation that we intend to make. It reflects the arguments that are contained in the briefing that have already been presented to the commission, and which the other side has had for months now. The proceeding here is a little unusual in the sense that when you file dispositive motions, in this case motions for summary judgment under the Ethics Commission's rules, you file a motion and there's a response thereto, but typically there's no reply. And so both sides have a situation where they weren't entitled to file a written reply brief to the final briefs that were filed in support of summary judgment motions. And so to the extent that this presentation is going to encompass those issues as well, I think that it should be admitted. It's certainly something I'd be entitled to argue. The fact that it's just been presented in written form, more than anything, was done as a courtesy so that people could follow along easier with our presentation. I could sit here today and read from my own notes, which is essentially what these are. I just thought it would be more fair for everyone to have the same thing in front of them as I went through the presentation.
Chair Wallen, may I respond?
Yes, I was going to ask you to do that.
First, I'd like to note that generally we do have a chance to reply in motions for summary judgment. That is something that in this specific matter, as Mr. Clant may remember, the parties actually agreed to specifically for this matter only. Generally, there is a reply. So we along with opposing counsel, made that decision. As a demonstrative exhibit, there is no reason this should ever be an exhibit that would be given to the commission. That would be improper. You know, opposing counsel speaks of fairness. Certainly sending any kind of even demonstrative exhibit that you plan to use 55 minutes before oral argument is not fair. Even in court or any other argument, sending something like a PowerPoint would need to be done in advance, not while I'm sitting waiting for the hearing to begin. I think it's totally inappropriate and absolutely the opposite of fair.
All right, counsel, I'm going to admit it, provided it does not contain any additional evidence. If it does, those items, Associate Counsel Bassett, you can raise the issue if it contains additional evidence.
Let me clarify, you're going to allow them to use it, or you're going to admit it as an exhibit?
To use it,
Okay, but it won't be admitted as an exhibit?
correct.
Okay, and when will I have a chance to object to anything that is new?
If they go through and there's something on the slide that they want to admit as evidence, then you can object at that time.
Thank you.
Okay? And we'll take it case-by-case basis. I think this is a good.
Chair
compromise.
Wallen?
Oh, Commissioner Yen.
Yes, will this be displayed on the screen as I was not provided a copy?
I believe it will be, right? Or are you guys able to do that?
I'm not sure if we can with the technology here. Maybe we can. When we had emailed it to everyone, we had asked that it be forwarded to Commissioner Yen, knowing that she was going to be participating remotely. We can certainly email it directly to Commissioner Yen, perhaps at her McDonald Carano email address, if that's easy, or in some other way so she can follow along. Or if there's a way to display it, we're happy to do that as well.
I think the ethics email is sufficient.
Our conflict counsel said that he'll email it to you.
Very good. Thank
Thank
you.
you.
Madam Chair?
Yes, Commissioner Moran.
Yes, thank you, thank you. And in terms of Ms. Bassett and Mr. Williams's comments, I just don't want to, I would ask that the commission allow Mr. Williams to be able to make his presentation without interruption. I would ask that Ms. Bassett take notes as to the items that she feels may or may not cause concern for her in her case. I don't want to see either of the parties disrupted with regards to their opening arguments. So I would ask the commission to be mindful of that. I would also ask Ms. Bassett and the executive director to be mindful of that when Mr. Williams goes through his presentation. I appreciate Mr. Williams preparing that for us to make it easy for us in terms of a roadmap. And I'm certain that he would give you the same professional courtesy if asked, Ms. Bassett and Mr. Executive Director. I'll put those on the record, Mrs. Chair, Madam.
Thank you, Commissioner Moran. I'm going to still allow Associate Counsel Bassett to object, and the other side can do as well. as we go
Sure.
through.
And Commissioner Moran raises a good point, because I want to make sure that I allow opposing counsel to make her presentation in the manner that she wishes. I do anticipate the potential to be objecting to one exhibit she may argue. I don't have an objection to the exhibit, and I'll just tell you what it is in advance so we're not playing hide the ball here. Exhibit 36 to their motion for summary judgment is a newspaper article from the Nevada Independent. I don't have a problem with that article being admitted for the purpose of showing what was in the public realm at the time. That's why we have not objected to it. But depending on the argument that gets made, and I don't know what it is yet, I may have an objection to that article being used in a different way that would constitute hearsay or potential double hearsay. And I don't want to interrupt, so I just want to make sure I've preserved that now, and maybe I can raise it in the manner that you suggest is most appropriate.
Mr. Williams, I will allow you to reserve that objection for that
Thank you very
exhibit.
much. Appreciate it.
Thank you. Right. Ms. Bassett, please proceed.
Thank you. Good morning. For the record, I'm Elizabeth Bassett. I'm the Commission's Associate Counsel, and I represent the Executive Director in these matters. In enacting the ethics law, the Nevada Legislature has declared that it is the public policy of the state that a public office is a public trust which shall be held for the sole benefit of the people. For those who have taken ethics training from our office, you may remember that the Executive Director points this out as the most fundamental ethics concept for all state officers and employees. Public officers are held for the benefit of the people of Nevada, not for the benefit of the people holding the public offices. What is at issue in the ethics matter before you today is a public officer who did not meet the standards set by the legislature, but who instead knowingly and repeatedly used government property to benefit his own personal and pecuniary interests rather than the interests of the people of Nevada. More specifically, the subject used government property to benefit his campaign for the public office in violation of the ethics law. The issues before you today are not ones that this commission is hearing for or deciding for the first time. Rather, the commission has addressed these issues numerous times over the last 25 years, and particularly in the last 5 years. This is not a matter of first impression. Over that time, this commission has consistently held that the ethics law prohibits Nevada sheriffs from using their uniforms, badges, and other equipment of their office, all of which are government-owned property, in support of any campaign, including their own. Looking at just the last 5 years, in 2018, this commission addressed the Antonoro complaints regarding a Nevada sheriff who campaigned for re-election using his uniform and badge. In those matters, this commission wrote, "A sheriff's uniform and badge signify the power and prestige of the office and are considered governmental property or equipment. Because the uniform and badge are government property, a public officer's use of them in a campaign creates an appearance of impropriety and violates NRS 281A 407, which prohibits a public officer from using government property or equipment to benefit a significant personal or pecuniary interest." As a result of the Antonoro matters, this commission sent a letter clarifying the issue of the use of uniforms and badges in campaigns to the Nevada Sheriffs and Chiefs Association in October 2019. At that time, subject's agency, the Las Vegas Metropolitan Police Department, was a member of the Sheriffs and Chiefs Association. That letter contained very specific guidance regarding the requirements of the ethics law, including the following language. The commission has determined that it is a violation of the ethics law for a law enforcement officer to wear or use his or her uniform, badge, or other physical accoutrement of office to support or oppose any political campaign. Specifically, a public officer or employee must not use official government resources in support of a political campaign. For purposes of this matter, government resources include, without limitation, an official uniform, badge, or other physical accoutrement of public office. The commission has previously determined that a public employee of a law enforcement agency is prohibited from using a uniform, badge, or other physical accoutrement of public office in support of his or her political campaign. A public officer or employee has a significant personal and financial interest in achieving or maintaining an elected position. A law enforcement uniform and badge signify the power and prestige of the office and are considered governmental property for purposes of the ethics law. The commission has now definitively concluded that no law enforcement official may wear his or her uniform, badge, or other physical accoutrement of office in support or opposition of a political campaign, including his or her own campaign. Such use constitutes a violation of NRS 281A 400 subsection 7. Following the Antonoro matters and the Sheriffs and Chiefs Association letter, this commission issued an advisory opinion in June 2020 on the same issue. In that opinion, this commission stated, simply put, public officers and employees are not entitled to take advantage of public resources to support their own campaign. The opinion also explained that the use of a uniform and badge in support of a campaign is a violation of both NRS 281A 400 subsections 2 and 7. During the 2021 legislative session, Assembly Bill 218 was introduced, which sought to change that law and expressly provide sheriffs with the right to campaign in their uniforms and badges. The minutes of a March 2021 hearing on AB 218 show that both the executive director of the Nevada Sheriffs and Chiefs Association and an employee of LVMPD were present at the hearing and testified in support of AB 218. AB 218 failed to pass, evidencing the legislature's intent that the ethics law's prohibition on sheriffs campaigning in their uniforms and badges remain the law. The hearing on AB 218 and its failure to pass took place just several months before subject announced his candidacy for governor in June 2021 on live TV wearing his sheriff's badge pin. During the same election cycle at issue in these matters, this commission has received or initiated complaints in 6 additional matters concerning campaigning in uniforms and badges. Of these additional matters, 2 that are most similar to these matters are in Ray Cochran, in which this commission determined that a fire chief's use of his badge and uniform in a scripted video endorsing a candidate which was posted to social media was a willful violation of the ethics law. In Ray Rodriguez, in which this commission found that the subject committed a willful violation of both NRS 281A 400 subsections 2 and 7 for each non-posed photograph in his uniform and badge that he posted to his own campaign website. This commission's application of the ethics law to a public officer's use of a uniform and badge in support of a campaign is well settled. Whether it is in support of their own campaign or the campaign of another, the use is a violation of both NRS 281A 400, 2, and 7. Having reviewed the commission's consistent and well-settled precedent in this area, the next question is whether the subject used his uniform and badge in support of his campaign for governor. There is no dispute regarding the facts in these matters. The parties have stipulated to all of the facts, specifically that the subject posted numerous posed photographs of himself on his campaign social media sites showing him wearing his sheriff's uniform and badge. The parties have stipulated that subject was a public officer at the time of his campaign for governor, that subject created photographs and videos featuring him in his sheriff's uniform or wearing his badge in support of his campaign, and that subject had both Facebook and Twitter accounts that belonged to his campaign, and that during even the limited time at issue in these matters, he posted 34 photographs and videos to those accounts featuring himself in his sheriff's uniform or wearing his sheriff's badge. None of these facts are disputed by the subject. Considering the stipulated facts, the requirements of the ethics law, and this commission's precedent, it is established that subject's conduct during his campaign for governor violated both NRS 281A 400 subsections 2 and 7. What remains for this commission to determine then is the number of violations subject committed, whether those violations were willful, and the penalty that should be imposed for those violations. The parties have stipulated that even during the limited time at issue in these matters, the subject used his uniform and badge to bolster his campaign for governor 34 separate times. In ruling on prior dispositive motions and at hearings, this commission has determined that each act by a public officer that violates a provision of the ethics law constitutes a separate ethics violation. In Re Ramos, this commission held that the subject committed 12 violations of the ethics law for repeatedly failing to disclose his interest in a matter, finding each failure to disclose to be a separate violation of NRS 281A.420 subsection 1. And let me clarify that his interest never changed. He failed to disclose the same interest over and over again. And this commission found that each time he failed to disclose that same interest, it was a separate violation. And in Ray Rodriguez, another case involving a public officer's use of his uniform and badge in support of his campaign, this commission found that each time the subject posted a photograph showing him wearing his uniform and badge to his campaign website constituted a separate violation of both NRS 281A 400 subsection 2 and subsection 7. Each of subject's 34 actions in using his uniform and badge in support of his campaign violated both NRS 281A 400 subsection 2 and subsection 7. Therefore, applying this commission's previous precedent, you should find that the subject committed 68 violations of the ethics law. In asking this commission to come to a different conclusion, subject may cite to stipulated agreements negotiated by the commission in which public officers stipulated to one or just several violations of the ethics law to resolve allegations of multiple acts violating multiple provisions of the law. In those matters, the subjects stipulated to and took ownership for their actions and violations of the ethics law, which is a very important aim of the commission. The next question to be considered by this commission is whether subjects' 68 violations of the ethics law were willful. In making that determination, the ethics law directs this commission to consider a number of factors, including the seriousness of the violations, including the total number of violations, any previous violations by the subject, mitigating factors, including any attempts to rectify the violations, the extent of any financial gain from the violations, and any other matter justice may require. This commission's previous opinions have been unequivocal. There are no circumstances under which it is appropriate for a public officer, such as subject, to use public resources to support their own campaign. And this commission has specifically held that a sheriff's use of their government-owned uniform and badge is in support of a campaign is a serious violation of the ethics law. Adding to the seriousness of subject's violations is the fact that he committed them knowingly. The facts in these matters show that this commission's 2019 letter to the Nevada Sheriffs and Chiefs Association, of which the LVMPD was a member, clearly explained that the use of uniforms and badges in support of a public officer's own campaign was a violation of the ethics law. Further evidence of subject's knowing and willful violation of the ethics law is his involvement in attempts to change the law through AB 218, which failed. Other factors that this commission must consider in determining the willfulness of subject's violations are any financial gain he realized as a result of the violation and whether he made any attempt to correct his violations. Subject realized the financial gain as a result of his conduct because he was elected to the office of governor, for which he receives a salary and benefits. There is certainly an argument that he makes less money as governor than he made in his previous position. That is not relevant to the consideration as to whether there was a financial gain for being elected as governor. Additionally, subject did not attempt to rectify his ethics violations, even after the commission provided him with notice of these matters. I looked, and notice of these matters were provided in September and then November of 2021. Even after those dates, subject continued to produce and post numerous additional photographs in his uniform and badge after he received those notices. This commission is also directed to consider other mitigating factors. As noted in our briefs, subject has no previous ethics violations. Additionally, since taking his office as governor, subject has requested and received ethics training for all of his staff, including himself. Both of these mitigating factors should also be considered by the commission in reaching its decision. As to the penalty to be assessed for subject's willful violations, the ethics law allows this commission to take any reasonable action that will remedy the violation or deter similar violation or conduct. The executive director requests that the commission censure the subject, impose the financial penalties contemplated by the ethics law, and require that subject designate an ethics officer within the governor's office. The ethics law provides that a censure is appropriate when the commission finds a willful violation and that there's evidence that the violation involved bad faith, malicious intent, or knowing or reckless disregard of the law. A reprimand would be appropriate if subject had committed willful violations, but there was not evidence that they were knowing or reckless. Here, as discussed, the evidence shows the subject was aware of the requirements of the ethics law and chose to violate the law nonetheless. Thus, his violations involved knowing and reckless disregard of the ethics law, and a censure of subject by the commission is appropriate. The ethics law also specifies the financial penalties that may be assessed by the commission for willful violations. The statutes provide that for each willful violation of the ethics law, the commission may impose civil penalties of up to $5,000 for the first violation, $10,000 for the second violation, and $25,000 for all additional violations. In the penalty matrix attached to the executive director's motion, we have calculated the maximum civil penalty that may be imposed for subjects' willful violations, which totals $1.665 million. A civil penalty in this amount, or even near this amount, would in fact be unprecedented. However, subject's conduct in these matters was unprecedented and therefore requires an equivalent penalty. The evidence shows that subject's violation of the ethics law was intentional, pervasive, repeated, and ongoing. The purpose of assessing a civil penalty is to deter similar violation or conduct by subject or other public officers in the future. The fines and other penalties imposed by the Commission for previous violations of the same ethics law clearly did not deter similar repeated violations by subject. It follows that a more significant penalty is warranted to deter subject and other public officers from knowingly engaging in numerous violations of the law, as we saw take place in these matters. However, it is up to this commission to determine the civil penalty that you believe will deter this conduct in the future. The executive director also requests that subject be required to designate an existing governor's office employee as an ethics officer who would receive training and technical assistance from the executive director. The aim of this request is for the governor's office to have the internal ability to prevent or mitigate potential future ethics violations within the governor's office. Thank you.
Thank you, Ms. Bassett. At this time, I'd like Mr. Williams to present any argument on Mr. Lombardo's motion for summary judgment and any responsive arguments to Ms. Bassett's.
Thank you, Chair Wallen. And again, Chair Wallen, fellow commissioners, my name is Colby Williams from Campbell and Williams. I have the pleasure of representing Governor Lombardo in this action. And let me just start by asking, can everyone hear me okay? Okay, great. Governor Lombardo has been a faithful public servant for more than 25 years, most of those in law enforcement. From 2014 through 2022, he was the duly elected sheriff of Clark County, Nevada, having been elected to 2 consecutive 4-year terms. As my colleague just pointed out, he has never been the subject of any ethics charges whatsoever in his distinguished career until now. And what are those charges? Are they charges for failing to disclose conflicts of interest? Or perhaps the unauthorized approval of salary raises? Or the unauthorized taking of compensation and sick leave accrual? Maybe the use of gift cards for personal purposes, or any of the other myriad of circumstances this commission has addressed where public officers or employees have received an unwarranted and a tangible benefit from their governmental position? The answer is no. Instead, the executive director seeks more than $1.665 million against Governor Lombardo because his campaign posted the same 4 images of Sheriff Lombardo in his uniform and badge to the campaign's website. And it did it 34 times, according to the executive director. We submit these charges, and the requested penalty are unauthorized under the applicable law and are a gross example of government overreach. And let me tell you why. I'm going to move through my presentation, and I'll indicate from time to time what page I'm on, but I believe everyone has a copy of it. But if anyone has any questions, just stop me and I'll indicate where I am. And right now I'm on page 3, which goes over the standards for summary judgment. We're here on cross motions for summary judgment. I know the commissioners have dealt with a motion for summary judgment countless times, so I will not waste time going over the standards, but I'm happy to answer any questions you may have. I do think it's appropriate to talk about the standard of proof in ethics cases. The executive director has the burden of proof here. As the representative of the government seeking to impose more than $1.5 million in fines, the executive director bears the burden of proving his case by the preponderance of the evidence. That's set forth in NRS 281A 790 subpart 9. And the preponderance of the evidence simply means the greater the weight of the evidence. I'm going to get to my conclusion right up front and advise our position is that the stipulated facts in this case do not prove by any evidentiary standard that Governor Lombardo either, and I'm going to quote from the language of the statute because I think that's critically important here, that he either secured an unwarranted advantage as is required under 281A 400 subpart 2, or that he, quote, benefited from the limited use of government property, sometimes referred to as accoutrements, under NRS 281A 400 subpart 7. There is no proof in any of these stipulated facts that these 34 postings of the same 4 images caused anyone to vote for Governor Lombardo, to give him a campaign contribution, or to provide him with any other benefit. The executive director's position, as articulated by his very fine counsel, is that the commission's prior precedent, and I wrote this down, the consistent and well-settled precedent establishes that what Governor Lombardo is alleged to have done here constituted a violation. Most respectfully, it does not. And we have to start our discussion by talking about what is precedent. Precedent, Black's Law Dictionary tells us, quote, is an action or official decision that can be used as support for later actions or decisions. There are different kinds of precedent. You have binding precedent. For example, if the Nevada Supreme Court or Nevada Court of Appeals had weighed in on a subject matter that was before this commission, I submit you would be bound to follow it. You also have what's known as persuasive precedent, which is not binding, but is nonetheless entitled to respect and careful consideration. An example of that may be a decision from the highest court of a neighboring state that was addressing an issue that was similar to what you may be considering. The executive director relies, as you've heard here, on several prior stipulated agreements and an opinion involving sheriffs to support his contention that Governor Lombardo violated 400 subpart 2 and 400 subpart 7. You're going to hear me referencing those statutes a lot, so I'm just going to use the shorthand, but if anyone has any question about what I'm talking about, just stop me. But we submit those opinions are neither binding nor persuasive. Why do I say that? First, 281A 710 subpart 1 requires the commission to interpret the applicable ethical standards in the context of, quote, a given set of facts and circumstances. In other words, you have to decide each complaint on a case-by-case basis. Second, every one of these stipulated agreements in this opinion, I say opinion because Kirkland was an opinion, the other sheriff's cases are stipulated agreements. We'll talk about those in a minute. Every single one of them, at the end of those agreements, expressly state that they are limited to their own facts and circumstances. And they even go so far as to say they are not applicable to any other proceeding. Every one of them. And I can pull them out here. So when we're talking about the well-settled precedent, they are limited to their facts. And that is important because the Nevada Court of Appeals, in a published opinion, has addressed this issue in the context of administrative bodies issuing opinions that are, quote, expressly limited to their facts. And what did the Nevada Court of Appeals tell us in the case Tom versus Innovative Home Systems? We have the site for you on our presentation. It said that the opinions of administrative bodies expressly limited to their facts aren't even persuasive authority in future cases, even if the prior cases arguably resemble the current case. And that makes sense. Why? Because any number of unique factors can go into a subject's decision to settle a case with the commission and the executive director. But one subject's decision to settle doesn't become binding or even persuasive in a future subject's case, even though that subject's case may arguably resemble the prior cases. In my world, dealing with litigation, people settle cases every day across this country. But those settlements don't become binding just because one of those parties may be involved in future litigation that's arguably similar to what was settled. But that's how the executive director and his counsel want you to treat the prior stipulated agreements. But there is another problem with that, And again, it comes from the Tom decision. And I would submit that the Tom decision is binding as a published opinion from the Nevada Court of Appeals addressing this issue. And what it also said is that those prior administrative decisions weren't persuasive because they addressed different facts than were before the case or the court at that time. And that, most respectfully, I have to disagree with my colleague here. That is the situation we face here. The commission has never addressed the factual situation we have here, where an elected sheriff used a limited number of photos depicting himself in uniform while campaigning, and this is the punchline, for a different partisan office, the office of governor. That is entirely different, I submit, than what you have dealt with before. This is a case of first impression. Now at page 10, we've got a lot of writing on the page summarizing the prior opinions that you heard Ms. Bassett talk about. I'm not going to go through them all factually, but I think I can sum them up this way. What they dealt with, starting with Kirkland and then again most recently in Coverly, was a sheriff in his using his uniform and badge to endorse a different candidate for a different office. In Kazanik, we were dealing with an undersheriff who used his uniform and badge in pictures that were put up on his website that were used in his campaign for sheriff. In other words, he was able to cloak himself in the uniform of the office for which he was running. Not the case here. In Pitts and Antonoro, you're dealing with a sheriff who was the incumbent, who was running for re-election as the sheriff. This situation presents none of those facts. But I do want to talk a little bit about Antonoro and the sheriff's letter, or the executive director's letter from October of 2019, which you heard Ms. Bassett focus on, because I think it's important, and I think it's the crux of their argument here as to why there is a violation. In Antonoro, again, we were dealing with an incumbent who was running for re-election. Even though 3 years earlier in Pitts, this commission found that an incumbent using his uniform and badge to run for re-election as sheriff did not constitute an appearance of impropriety under 400 subpart 7. Just 3 years later, with no change in the law, in Antonoro, you reached a different result. The different result was, we do now say under 400 subpart 7, it's an appearance of impropriety to use your uniform and badge when running for re-election. But you know what, Sheriff Antonoro? We're dismissing all the charges against you. Let me repeat that. Even though you made that pronouncement, you still dismissed all of the charges against him. He wasn't fined a cent. Neither was Pitts. Those cases were dismissed. Neither was Kazanik. Neither was Kirkland. And neither was Coverly. So when we're talking about this consistent treatment of sheriffs, there's one thing that was consistent. You never fined one of them. Now he wants $1.6 million. We'll talk about that later. But what the executive, as a result of Antonoro, what was agreed is that the executive director would send a letter to the Sheriff's Association advising of the commission's new position that wearing your uniform and badge constituted an appearance of impropriety when the incumbent sheriff is running for re-election. Is that what the executive director did? No. And I should stop right here and point out, when I'm talking about the executive director, it is not Executive Director Armstrong. This is a prior opinion from a prior executive director. But what that executive director did is took it even further. Went to a place where this commission had never been in Antonoro and said as follows on page 11 of our slides. It is a violation of the ethics law for a state or local government law enforcement officer or employee to wear his or her uniform, badge, or other physical accoutrement of office or official letterhead or governmental email to support any political campaign. Any. So the executive director took it further than anything that was addressed in Antonoro. Now, is the executive director permitted to do that? Our position is no. Even if this commission had issued an advisory opinion, if the 6 of you had gotten together and issued a published opinion that constituted an actual advisory opinion, it still has no binding force under Nevada Supreme Court law. That's the Dunphy decision. I don't think the executive director's letter even qualifies as an advisory opinion, but even if it did, it's not binding. And so at the end of the letter, when the executive director says this constitutes precedential guidance and we can use it to enforce it on law enforcement officers, most respectfully, we disagree with that. As I've indicated, the scope of the opinion goes broader than you ever went in Antonoro by purporting to apply to any campaign, not just incumbent sheriffs running for re-election. The opinion, I should note, is also, it is only based on 407. So when you hear a little bit of blending that we've always found there's a violation of 400 subpart 2 and 400 subpart 7, most respectfully, you haven't. The sheriff's letter only dealt with 400 subpart 7, never mentions 400 subpart 2. And this may be a good point to tell you that in every single prior sheriff's case that we've talked about and that's been before you, there has been no finding of 400, a violation of 402 in none of them. None. So this consistent and well-settled precedent, there's never been a finding of a violation of 400 subpart 2. So it's consistent and well-settled that there's no violation, not that there is a violation. But the biggest problem with the executive director's letter is it essentially wipes out the limited use clause, or excuse me, the limited use exception contained in 400 subpart 7. We're going to talk specifically about that exception in more detail. But by taking the position that any use of the uniform constitutes a per se violation, because it's always an appearance of impropriety, you have wiped out a section of NRS 281A 700, 400 subpart 7A. Again, this administrative body, and certainly the executive director, is not entitled to do that. An administrative body cannot nullify a law through the guise of interpreting it. And the Nevada Supreme Court has addressed that in the analogous context of an administrative body passing a regulation that has the effect of wiping out a law it's intending, or contradicting a law it intends to interpret. Respectfully, you can't do it. The point of all of this is that the executive director's letter that is so heavily relied upon by the executive director here is not precedent either. Moving on to page 12, we've cited the Coverly case. I don't need to go over that again. That was an endorsement case. There was a finding of a violation. It was non-willful, no fine. But there are some ethics opinions out there that do address the conduct that is before you. These are opinions from the Office of Special Counsel for the United States of America interpreting the Hatch Act. And I'll start off by saying I know you all have addressed the Hatch Act on multiple occasions dealing with sheriffs and other public officers and officials, and I will acknowledge right up front, it is not binding on you. So I'm not trying to be hypocritical and say that it's binding, because it isn't. But I do submit it should be found to be persuasive, because it does address the factual scenario we're dealing with here. In 2012, it specifically looked at a sheriff's ability to use his or her uniform when running not just as an incumbent, but for a different partisan political office, and it said, no problem. It's not a violation. And it did so because Congress has granted elected officials, which Governor Lombardo, then Sheriff Lombardo, now Governor Lombardo was in his capacity as sheriff. It grants them greater latitude to engage in political activities because their principal employment is that of political office. And so it exempts them from some of the provisions of the Hatch Act. But sheriffs and law enforcement officers don't get a free pass. They don't get to do whatever they want with the uniform. What's nice about the Hatch Act opinions is it specifies the types of things that would constitute a violation or an appearance of impropriety. You can't go door to door canvassing a neighborhood in your uniform, which would be perceived as coercive to someone that feels compelled to answer the door for law enforcement. You can't require people in your department to give you money, to vote for you, or to otherwise work on your campaign. That's improper because it gets at the heart of what I think you truly are concerned about and should be concerned about, and that is the notion of some official sanction of the sheriff's office supporting a particular candidate. That's not what's going on here, because that is problematic, and that's why you can't coerce your subordinates to do that, and Sheriff Lombardo isn't accused of doing anything like that. I'll note that the other sheriffs were. Mr. Pitts, who all of his cases and counts were dismissed, he had a bunch of people in the department working for him, as did Antonoro. All charges dismissed against both of them. Sheriff Lombardo was doing nothing like that. Another thing that would be prohibited is offering leniency to somebody in exchange for a vote or a contribution. You can't do that. These are examples of standards that can be followed and determine whether there is a violation or not this nebulous concept of what is an appearance of impropriety. And although the Nevada Legislature and the Nevada Supreme Court haven't weighed in on this, that's one of the reasons that you found Pitts was entitled to a dismissal and Antonoro as well, that Nevada law was unclear. Nothing has changed in Nevada law, by the way. Nothing has changed since that time. We hear about these opinions, but I've already told you why they aren't precedential. But I do submit there is something significant in the absence of Nevada law on something, and it is this. If the legislature believed that a sheriff engaging in political activities was so problematic and created appearances of impropriety and all of these other violations of the public trust that you've heard about, there's an easy way to solve it. Make sheriff a resign to run position. Everyone knows, it's undisputed, that sheriff is the only elected office that requires that office holder to wear a uniform, to be on call 24 hours a day to respond to emergencies. If this was going to be a problem, if such an individual decided to run for different office, make that office resign to run, you eliminate the harm. The fact that the legislature has never seen fit to do it the way it does with judges, I think is significant. So in the end, as it relates to these opinions, the bottom line is this commission's prior agreements or opinions that address sheriffs making limited use of their uniforms and badges is different than the case we're dealing here, because Sheriff Lombardo was running for a different partisan office. The executive director hasn't cited you any case law or any authority from anywhere in the country prohibiting such conduct. The only authority that's been presented to you that addresses this conduct are the Hatch Act opinions, which allow it. Again, they are not binding on you, but I submit they should be considered persuasive. So let's now get to the specific statutes Governor Lombardo is charged with violating. And we'll start with 400 subpart 2. The relevant language is that a public officer or employee shall not use the public officer's or employee's position in government to secure an unwarranted privilege or advantage for the public officer or employee. The term unwarranted is now defined in the statute to mean without justification or adequate reason. Prior to that statutory definition, this body interpreted the term unwarranted to mean something that violates state or local law. You did that in the Kirkland case, you did it in Pitts, and you did it in Antonoro. Doing it in Antonoro, I submit, is significant because that was in 2019, after the statutory definition had been added. So the historical interpretation is obviously still significant in that regard. So continuing with the historical interpretation, no one can argue that what Sheriff Lombardo did here violated any state law or any local law. As you recognized in Pitts, and nothing has changed, Nevada law doesn't address the subject. It certainly doesn't prohibit it. The Clark County Code, which would have been applicable to Sheriff Lombardo at the time addressing conflicts of interest, likewise does not address the subject, certainly doesn't prohibit it. Metro's political activities policy, though, does address it. And while it does prohibit the use of the uniform in most situations regarding political activities, there's an exception. And the exception is that a law enforcement officer is permitted under the manual to wear his or her uniform in his or her own campaign, because it is not viewed as an endorsement. Again, the executive director's letter that we've talked so much about has no bearing on this issue because it doesn't address 400 subpart 2. So certainly under the historical interpretation. Governor Lombardo did not receive anything unwarranted. Under the statutory definition, we would likewise submit there is nothing unjustified or without adequate reason about Sheriff Lombardo's limited use of his uniform and badge in campaign materials. He has a First Amendment right to advise the voters of his status as the duly elected sheriff. I would submit that that is political speech that goes to the core of the First Amendment. And if you're going to regulate that, it's got to be narrowly tailored and it has to survive strict scrutiny. But even more important than that, there is no evidence in the record that Governor Lombardo's limited use of these same 4 images secured him any advantage, let alone an unwarranted advantage. Look through all the stipulated facts you want. There's no stipulated fact that says by posting these 4 images, so-and-so voted for him, or that so-and-so gave him a donation, or that he received any other benefit. The argument that you have heard from the executive director and his counsel is that, well, we have these prior cases that we say apply, we say they don't, and because of those, there's a violation. But you have to apply the facts to the law, to the statutory language. He's got to have secured an unwarranted advantage. There is zero proof in this record he got any advantage. This is summary judgment. You can't speculate, and it can't be based on attorney argument. So the suggestion seems to be, well, he won. He had to have received an advantage. But most respectfully, quote, this is from the Ninth Circuit Court of Appeals, there may not be less than 1,000 factors which enter into the vagaries of an election. What does that mean? It is impossible to prove why someone wins or loses an election. So saying that posting 4 images in a uniform and badge caused him to win, under the law, you can't do it. It certainly hasn't been done here. And there's another reason why you can't prove causation, and it's because Governor Lombardo wasn't the only person depicting himself in the sheriff's uniform and badge. Who else was doing it? The media, of course. Chair Wallen has ruled on the issue with respect to the exhibits. There are plenty of them in the record where the media was routinely reporting on this campaign, the governor's race, and depicting Sheriff Lombardo in his sheriff's uniform. So I ask you, how can you distinguish between posting 4 images on a campaign website and the media continually portraying him in his uniform and badge and say he received an unwarranted benefit from the posting of the images? Respectfully, I submit you cannot do that. There is another reason why you can't do it, because it wasn't just Governor Lombardo, or excuse me, then Sheriff Lombardo, and it wasn't just the media depicting him in his uniform and badge. At page 18, we have a still shot of then Governor Sisolak depicting Sheriff Lombardo in his uniform and badge to make the exact opposite argument that the executive director makes, to say being sheriff is a negative trait. Being sheriff is a disadvantage in this race because I don't think he did a good job as sheriff. He won't do a good job as governor. So what the executive director's position essentially requires is for a law enforcement officer who decides to run for elected office to campaign with one hand behind his or her back. What do I mean? Well, if an opponent is allowed to take pictures of the law enforcement in his or her uniform and create campaign ads about them, the executive director's position is that the law enforcement officer has no right to respond in kind. He can't combat a negative ad depicting him or her in their uniform with a responsive ad saying, no, I am good. I am worthy of your consideration, even though Governor Sisolak thinks it's a negative trait. Think about this example. Sheriff Lombardo routinely had to give press conferences to deal with law enforcement emergencies or what have you. Nothing would stop an opponent in a campaign from taking that press conference, slicing and dicing it, and presenting it as a campaign ad that they thought portrayed Sheriff Lombardo in a negative light. But under the executive director's reasoning, Sheriff Lombardo couldn't take images from that same press conference and create his own campaign ad that responded to it. I submit that is an inherently unfair outcome of what the executive director is asking here. It does not promote public confidence and trust in Nevada's ethics laws. So to wrap up on 400 subpart 2, the limited use of the badge and uniform in those images did not violate any policy, state, law, or any applicable county code. It certainly didn't secure any advantage, let alone a proven unwarranted advantage, and it was justified, and Sheriff Lombardo had adequate reason for posting those 4 images. We should submit that this charge should be dismissed, not the least of which because, as I indicated earlier, in every single one of your prior sheriff's opinions, stipulated agreements, or opinions, there has never been a finding of a violation of 400 subpart 2. Never. Let's move on to 400 subpart 7. This statute, in relevant part, prohibits a public officer from using governmental time, property, equipment, or other facility to benefit a significant personal or pecuniary interest. Importantly, as I've previewed, there is an exception to that prohibition in 400 subpart 7A. It's what we've referred to as the limited use exception. Limited use of government resources is permitted if you satisfy 4 prongs. The first is there has to be an authorized established policy allowing it. We've talked about that. The Metro policy allowed it. The use does not interfere with the public officer's performance of public duties. I want to stop here for a minute because I think this is critically important. The executive director has stipulated to the first 3 prongs that Governor Lombardo satisfied the first 3 prongs of this limited use exception. The second one, again, the use does not interfere with the public officer's performance of public duties. Do you remember how the Executive Director's Council started her presentation? That public trust is the most fundamental concept in the Ethics Commission's orbit, in these ethics laws that govern public officers, employees. They've agreed he didn't do anything that interfered with the performance of his duties. That's the public trust. The public trusts him to perform as sheriff. They've stipulated he did. Third, any cost associated with the use has to be nominal. They've agreed that it was, assuming there was any cost at all. And finally, the use does not create an appearance of impropriety. The only issue here with respect to whether the limited use exception applies is whether Governor Lombardo, then Sheriff Lombardo's conduct created the appearance of impropriety. And I'm on, just for reference, page 22 now. Appearance of impropriety, unlike the term unwarranted, which we talked about a moment ago, is not defined in the ethics statutes. It is a subjective standard. It is freestanding. In other words, there are no examples around it to help give you guidance. Frankly, I am sympathetic to this commission's efforts to have to try to interpret and apply this standard. It is wholly subjective and requires subjective judgments to be made. And I think that's part of the reason why there has been changes in the attitude or in the opinions that have come out or the stipulated agreements that have come out involving sheriffs when interpreting this phrase. So what we heard the executive director argue this morning, and also it's in their papers, is they rely on a case, it's an abstract opinion called In Re Public Officer. And they cited it for the prospect that there's now this clear and bright line that has been articulated. I would disagree with that for reasons I've gone over, but what that opinion does do is it tries to put some context around what appearance of impropriety means. And it relies on Black's Law Dictionary, and what it says is, conduct or status that would lead a reasonable person to think that the actor is behaving or will behave inappropriately or wrongfully. That's how In Re Public Officer tries to define the statute. But in the executive director's papers and in their presentation today, I haven't heard any explanation why a reasonable person would believe that when Sheriff Lombardo campaign depicted him in 4 images that were admittedly posted multiple times in his uniform and badge, would think that he is behaving inappropriately. After all, there's no dispute he was the duly elected sheriff of Clark County. He wasn't portraying himself in an inaccurate manner. He was running for a different partisan office. In other words, he wasn't cloaking himself in the uniform of the office for which he was running. He was running for a different partisan office. Again, we've talked about the fact that sheriffs are never off duty. They are the only elected official required to wear a uniform. So the public wouldn't think there's anything wrong with that. Again, he was also routinely depicted by the media and by his opponent in his campaign in his uniform and wearing his badge. The point of all of that is that if we look at this definition of appearance of impropriety relied on in in re public officer, there is no evidence presented to you to say why Sheriff Lombardo's conduct meets that definition. None. And again, I would go back to the fact that they have stipulated that posting those 4 images did not interfere with Sheriff Lombardo's performance of his duties. So what is the basis of the argument? Again, we go back to the sheriff's letter that was sent in 2019 and its pronouncement that wearing a uniform or badge to support or oppose any campaign violates 400 subsection 7. But as we've explained, that opinion is not binding. It is a departure from all other interpretations of 400 subsection 7A dealing with appearances of impropriety, because it now purports to apply to any use of the uniform in any campaign, never had been before this commission. And it effectively eliminates the limited use safe harbor provision that the legislature added to 400 subpart 7. And for these and the other reasons I've gone through, that's why we have argued the appearance of impropriety standard is unconstitutionally vague as applied to Sheriff Lombardo's conduct. We've cited in the papers, and we've included on page 23 of our presentation, a quote from the Kerrigan case that involved a review of some issues arising out of the Ethics Commission, and it identifies the standard for being able to show vagueness. There's 2 ways to do it. You can argue that a statute is facially vague and it's vague in all of its applications. We're not arguing that. That's prong 1 that we have quoted here on 23. But prong 2 deals with as-applied challenges. And you can mount a vagueness challenge if a law is so standardless that it authorizes or encourages seriously discriminatory enforcement. And while the ethics statutes don't impose criminal penalties, they obviously have the potential to impose some pretty significant civil penalties. This is probably the best case that exemplifies that point, given what the executive director is asking for. And for that reason, the laws have to be sufficiently explicit to inform those who are subject to it what conduct will render them liable to its penalties. So what conduct constitutes an appearance of impropriety? The law doesn't tell us. It doesn't tell you, most respectfully. When the Nevada Supreme Court has had to deal with this standard in the context of attorney disqualification issues, it, along with courts across the country, have routinely described the standard as being arbitrary and hopelessly ambiguous. We agree. And I think, some of the commission's decisions in this area exemplify that point as well, most respectfully. Again, going back to Pitts, which was decided in 2016, everyone on the commission recognized Nevada law was unsettled in the area because it didn't address the issue. The only authority that did address it, the Hatch Act opinions, allowed the conduct, and for those reasons and others, you dismissed all the charges against Pitts and said no violation. Just 3 years later in Antonoro, the commission changed, even though the law hadn't, and found it now was an appearance of impropriety to use your uniform and badge as an incumbent running for re-election as sheriff. Again, no change in the law. And then just a month and a half later, when the executive director issues his letter, or her letter, I believe it is, the law, or not the law, but the purported position of the commission changed again because now it applied to any campaign. So 3 years, 3 different interpretations, no change in the law. Because of the subjective nature of the standard, that's what creates this erratic history. And that's the epitome of a standardless law that could lead to discriminatory enforcement. So in addition to our vagueness argument, I would just close this section by saying there has likewise been no proof by a preponderance of evidence that Governor Lombardo actually benefited from the limited use of his uniform and badge. Again, no votes, no donations, no other benefit identified. So let's talk about willfulness. I'll stop and just to recap say our position, of course, is that there has been no violation of either statute and the case should be dismissed. But if the commission doesn't agree with me, then we have to move on to a couple of other inquiries. The next one is willfulness. And my colleague spent some time on this, and I don't need to belabor some of the same points that she made. The statute sets forth 7 factors. I've got them listed for you on page 26. I want to focus on a different subsection of that statute, though. And that's NRS 281A 775 subpart 3, which requires the commission, quote, to treat comparable situations in a comparable manner and shall ensure the disposition of the matter bears a reasonable relationship to the severity of the violation or the alleged violation. You didn't hear my colleague talk about that. I'm going to spend a lot of time on it in just a few minutes. But let's talk about the factors. Seriousness. Let me just say that Governor Lombardo and his council take these ethics laws very seriously. This body has a very serious job to do, and I know that it takes it seriously and does the absolute best that it can. We recognize that. As it relates to the conduct at issue here, though, when we're talking about the posting of 4 images to a campaign website that honestly did nothing more than highlight an undisputed fact that the public already knew, that Sheriff Lombardo is the duly elected sheriff, we submit that is not a serious violation. Again, others, and we've provided examples of this in our papers, in our exhibits, other office holders have likewise made limited use of government property or accoutrements in their campaigns. DAs in courtrooms, city council members on the dais in a city council's chamber, U.S. senators on Air Force One, even Governor Sisolak wearing his governor's pin and his governor's windbreaker at events. We aren't submitting those are violations at all. We think that they fall squarely within the limited use exception of 407, and we submit Governor Lombardo's conduct, then Sheriff Lombardo's conduct does as well. And again, is another argument why this isn't a serious violation. If the legislature truly thought that this created serious harm, a sheriff engaging in limited political activities, make it a resign to run position. It's never done that. Governor Lombardo has no prior history of ethics issues. The costs here have been minimized through our stipulated facts and hearing procedure. Mitigating factors, the Executive Director's Council was kind enough to point out a couple. I'll point out another, which is this is a case of first impression. And in all cases of first impression that I've reviewed, I haven't found one where you imposed a finding of a violation or a fine. This is not a case that requires restitution or reimbursement. Financial gain, again, if you look at the language of the statute, the financial gain has to result from the alleged violation. In other words, you have to say he won the election because of the violation. For reasons I've already gone through, you can't do that. You can't show he got any votes. You can't show he got any campaign contributions. And yes, in fact, the governor's salary is less than the Clark County Sheriff's salary. So did he really gain in a pecuniary or financial sense? I don't think so. And finally, with respect to another factor I think you should consider, I think our vagueness argument is different than a lot of the other cases that have been before you, and I think that's an important factor to consider here. So, again, our position, no violation. If you're inclined to consider the possibility of a violation, it's not willful. If I haven't convinced you that it wasn't willful, then we have to talk about what kind of penalties you're permitted to impose. And I will start by saying here that even if you find a willful violation, you're not obligated to impose a fine. It is still discretionary with this body. As I've said many times, and as his counsel has said, the executive director seeks to impose a fine of $1.665 million. You heard how he gets there, claims 34 violations of both 400 subpart 2 and 400 subpart 7, then says it's $5,000 for the first violation, $10,000 for the second, and $25,000 for the next 66 violations. This is wrong for at least 3 reasons. The first is there is no statutory basis for it. You have to look at the language of the statute. The statute is 281A 790 subparts 1A through C. It does not permit the commission to impose serial or aggregated fines for each violation of 281A 400 subpart 2 or subpart 7. The statute only allows the commission to impose civil penalties not to exceed $5,000 for the first willful violation, $10,000, this is important, for a separate act or event that constitutes a second willful violation, and $25,000 for a separate act or event that constitutes a third willful violation. That's where the statute stops. Period, full stop. It does not go any further to talk about fines for 3 or more violations or a 4th violation. It doesn't do that. So, the statute provides no authority to double count the exact same conduct as being violative of the 2 subsections of the same statute. It only allows for fines for separate acts or events, and it does not contain any language allowing civil penalties beyond the 3rd willful violation. The legislature could have said something different. It could have easily drafted the statute to say you can impose civil penalties for each violation. There are different statutes in dealing with different subjects that have that language. It could have said that you can impose a fine for every willful violation of the statutory scheme, but it didn't do that either. It could have said that you can impose a fine of $25,000 for the 3rd and each subsequent willful violation. It didn't do that either. These omissions, when you're talking about the way you construe a statute, are deemed to be intentional. If the language is unambiguous, and we submit that it is, then you stop at the plain language. There is a subsection of the statute that does contemplate the possibility of 3 or more violations, but it doesn't do so in the context of fines. It only does so in the context of potential removal. So that too, when you're looking at rules of statutory construction, supports our interpretation, because that variation in language, the fact that the legislature knew how to say it if it wanted to in one place and didn't say it above when it was talking about fines, means that difference in meaning is purposeful and the omission is intentional. While we don't believe you should fine Governor Lombardo anything, respectfully, under the statutory scheme, the most you can fine him is $40,000 if you find 3 or more willful violations. The next problem with the executive director's requested penalty here is that it is entirely inconsistent with comparable cases. And I've heard the preview of what the argument is for that, and that is other people who entered into stipulated agreements get treated better than someone who's going to contest the validity of the violation in the first place. I don't think the law allows you to do that, and I'll explain why. The statute imposes the obligation to treat comparable situations in a comparable manner. 281A 775 subpart 3. We're talking about the penalty phase. The first phase is there a violation or not? If someone wants to stipulate to a violation, fine. But if someone wants to contest it and you ultimately disagree with it, this statute still kicks in when we're talking about what's the penalty imposed. There's nowhere in the statutory language that says those people who settle get a break, those who want to challenge the violation get hammered. That's not in there. Look as long as you want. It's not there. You have to treat comparable situations the same way. There is no case in the history of this commission that has sought the fines that are comparable to what are being sought here. The The highest fine, all of your records are public, all of your decisions, opinions, et cetera, are public, you know that. The highest one we have found is a $15,000 fine imposed against Kathy Augustine. The fine here is 111 times higher than that highest fine. It is 10 times higher than Governor Lombardo's annual salary. And consider this, it is 1.665 million times higher than the highest fine you have ever imposed on a law enforcement officer that was before you previously. Why is that? Because you have never imposed a fine of a single cent against any prior sheriffs or undersheriffs. Now he wants $1.665 million. The charges out of Governor Lombardo do arise out of a single course of conduct, yet the executive director wants you to treat it as 68 separate violations. And what is the basis for this? You were told to look at the Bartolo-Ramos decision on summary judgment. That was at their opposition, page 12, exhibit 41. And it was referenced here again today. But there's a problem with that. The stipulation that ultimately got entered, and we have the site here for you, it's 22-026C, has the following quote: consistent with several prior stipulations approved in other matters, the commission has combined a series of occurrences related to the same conduct into a single violation for purposes of resolution of a case. Mr. Ramos's violation, he was, I believe, the director or county manager for Lander County. He had approved a contract that he had a personal interest in as a result of a family relationship, and he didn't disclose it. And then at 9 different county commission hearings, he approved 17 different invoices on different projects. This commission still treated it as a single course of conduct. That is not the only example. There's a case involving a gentleman named Bryce Bolt, published on your website, case number 17-37C. He was found to have violated both 400 subpart 2 and 400 subpart 7, just like the allegations against Governor Lombardo. What he had done is he was found to have secured an unwarranted advantage or benefited a pecuniary interest because he entered the Boulder City Secure Records Storage Area 162 times on 80 different days where he would spend the night for whatever reason. This commission treated it as a single course of conduct, resulting in a single violation for which he was fined $1,000. Even in the cases involving the use of uniforms for campaign purposes, the commission has treated multiple uses in the same campaign as a single course of conduct. Kazanik, Coverly, and Cochran. Kazanik and Coverly are sheriff's cases. Cochran was the Reno City Fire Chief, and it's worth talking about him for a second because Ms. Bassett did. Cochran endorsed Catherine Cortez Masto in her senatorial race. He allowed his image in a uniform, not an official uniform, but in a uniform that looked like the fire department uniform, to be used in a television commercial that aired, to use your language in the opinion, repeatedly on TV. And yet, he was found to be in violation. That was found to be a willful violation, but you didn't impose any fine on him, and you found that it was a single course of conduct. It's very analogous. I do agree it's analogous in that sense. If you want to talk about an image being posted 4 times, or excuse me, 4 images being posted 34 times, and a television ad that aired repeatedly, to say one arises out of a single course of conduct and the other one doesn't, I think doesn't treat comparable cases comparably. Again, to wrap up this section, prior to the filing of the complaints against Governor Lombardo in this matter, there is not a single stipulated agreement or opinion that has found a willful violation or imposed a fine against a law enforcement officer for wearing his or her uniform for a campaign-related purpose. Not one. The reference to Rodriguez that you just dealt with a couple of months ago, I'm not even sure that's a final opinion yet. I don't know if that's been appealed. I haven't seen a final. I watched the transcript. I haven't seen a written order result from it. But assuming that it is, that was filed after the complaints against Governor Lombardo. So those didn't constitute any sort of prior notice to him. The final problem with the requested penalty is that it's unconstitutional. We submit it violates the excessive fines clause found both in the United States Constitution and in Nevada's Constitution. Before I get to those, all we really need to do is go back to the language that governs this body. Recall I referenced 281A 775 subpart 3, talking about treating comparable cases comparably, but it says something else that's equally as important. The disposition of the matter must bear a reasonable relationship to the severity of the violation or alleged violation. That's similar to the analysis you apply under the excessive fines clauses. The touchstone of such an analysis is proportionality. The U.S. Supreme Court tells us that the amount of the forfeiture must bear some relationship to the gravity of the offense that it is designed to punish. And the Nevada Supreme Court has told us that the excessive fines clause applies to civil penalties, like we're dealing with here. So what we have is the executive director seeking to impose civil penalties on Governor Lombardo in the amount of $1.665 million for a purported violation that is not a crime, did not cause any financial harm to the public, it did not mislead the public, and it did not create any identifiable advantage for Governor Lombardo in the gubernatorial race. It occasionally highlighted the undisputed fact that the public already knew. He was the duly elected sheriff of Clark County. Most respectfully, it is disproportionate to ask for $1.65 million for engaging in that conduct. I had a couple of other slides here I don't think I need to get into because I didn't hear the executive director argue anything about impeachment, so I'm going to save everyone at least a tiny bit of time and not get into that unless I need to later on. And I do have a slide that sort of wraps up our position. That's at page 40. I don't know if I'm stepping on my own toes regarding a closing argument, but I'll just quickly go through the points quickly. Our position is that there's no violation of either statute and that the case should be dismissed. If the commission finds a violation of any kind, our position is that there has been no showing of willfulness, not the least of which is because this is a case of first impression, and thus there should be no fine. If the commission does find a willful violation, it is not obligated to impose a fine in any amount, but we submit, if you're inclined to do so, any violations should be deemed to arise out of a single course of conduct and result at most in a single violation consistent with all prior comparable cases. And in that regard, the maximum fine is $5,000. If you find 3 or more, the maximum fine is $40,000. I know I've gone on for a long time, but as I've said, this is a serious case. I know the commission takes its job seriously, and I wanted to make sure I covered all of the different arguments that I think are applicable here and all of the different issues. I appreciate your patience in allowing me to do so. Thank you.
Thank you, Mr. Williams. At this time, we're going to go and ask Ms. Bassett to present any additional arguments or responses.
Am I close enough for you guys? First, I would like to clarify, there were a number of statements made by my opposing counsel that this commission has never imposed a fine for, wearing a uniform and campaigning, has never found a violation of NRS 400 subsection 2. As you all are aware, that is incorrect. Those were both found in the Rodriguez case, which does have a final written opinion publicly available, and so those statements are factually inaccurate. Both of those things have been found and have been levied by this commission. First of all, I'd like to discuss stipulated agreements. This commission is very aware of what stipulated agreements say, how they apply. You have to approve each one that is entered into. Opposing counsel has misstated what the stipulated agreements say. The stipulated agreements contain language that say they are only applicable for the ethics cases. They can't be used in a criminal matter. They can't be used in a civil matter. Opposing counsel is very aware of that because we specifically discussed that fact. There is not language that says it cannot be used as precedent in any other ethics case. It cannot be used against the subject in a criminal or a civil case. That is what the language within our stipulated agreements say. Looking at comparable cases and stipulated agreements, you cannot call what the resolution of a stipulated agreement comparable to the outcome of a adjudicatory hearing or a dispositive motion. I mean, here we have agreed to forego an adjudicatory hearing in lieu of this hearing, so they're analogous. The difference in a stipulated agreement is that that particular subject has come to the table, has agreed that their behavior, their actions violated the ethics law. They have agreed to take training. They have often agreed to an admonishment or a censure of some kind. They have agreed to publicly take responsibility for their actions, and in return, because that is the main part of what we do. The Ethics Commission's main focus is to educate and to prevent future violations of the ethics law, both by the subject in front of us and by other subjects. And so part of what it goes into a stipulated agreement is that this subject is coming to the table and making an agreement with us that they in fact violated the ethics law, and that they are making an admission to that fact. That is not the same as going to a contested hearing where the argument is, I have not violated the ethics law. I have not done anything wrong. So the outcome and what is asked for would certainly not be the same. A stipulated agreement before the Ethics Commission is also nothing like a settlement in civil litigation, as opposing counsel referenced. Those stipulated agreements are outside of the court process. They have no binding precedent later like ours do. That's an agreement between two parties to reach a private agreement. Our stipulated agreements are always public. That's part of what we do. Part of what the Ethics Commission is about is that we don't allow public officers and our employees to engage in behavior and then resolve that in private. It's public. So when they reach that settlement, it is a public document. It's a public admission. They know that going into it, and they are written with that intent and purpose. That's why they come before the commission. That's why you guys have to approve them. They are considered to be final administrative orders. They're cited as such. That's what they are. They are not analogous in any way to private settlements in civil litigation. Council went through a number of our previous cases. We went through a number of them in our briefs. Many of you are personally aware of them. But in making their points, council has left out many of the important facts or factors that weigh into why each of these cases came out the way they did. For instance, in Antonoro and in what was the other? And in another case where where no willful violation was found and no fine was ultimately levied, was that there were reasons. In one of them, they had received legal counsel that they were allowed to wear their uniform. In another, there had been a presentation by the Nevada Chiefs and Sheriffs Association saying they were allowed to. There were instances in those cases that are not present in this case, by any stretch, that impacted the outcome of those cases. So you have to look at them as a whole, which we do in our briefs. Council talked a lot about how the crux of our argument and everything we're relying on is the 2019 letter. That's not correct. The 2019 letter discusses the previous law of the commission. It brings it all together because in the Antonoro case, Mr. Antonoro was trained by the Nevada Sheriffs and Chiefs Association incorrectly. So he campaigned quite a bit in his uniform and badge, and then when a complaint was brought against him, the defense was, but I was told I could do that. So the purpose of that letter was to say, here is the law as it is. You should let your members know what the law is so nobody else gets into this situation where they have an ethics violation. The law that is in that letter is the law as had been decided by the commission over the years and in numerous cases. That law is not erratic as it's represented. The law grows as the different complaints come before the commission. The commission deals with the complaints that come before it, the advisory opinions that come before it, and has to deal with them on a case-by-case basis. But most of the law we're citing to is still in Ray Kirkland, which is back in 2014. It's the same cases that have been in place for a long time. There is no back and forth in different ways that this commission has decided. It has been a very consistent growth and application of the uniform law. It has never changed. There's no case out there that says you can wear your uniform while you campaign. That doesn't exist. Every case says you cannot. For instance, opposing counsel cited to the recent Coverly case. Most of this commission is very aware of that case. There's many differences between the Coverly case and the current case. The Coverly case, the appearance was at an event. It wasn't an ad. And in that case, Sheriff Coverly immediately recognized that he had violated the ethics law. He absolutely cooperated with us. He changed his behavior, and he engaged with us and had his entire office trained. That's why a stipulated agreement with him has it comes out the way it does, because there is a different engagement with our office. And that is what we're looking for as the Ethics Commission. We want to educate, we want to deter. We don't want to be in the situation where we're prosecuting ethics violations. We want to be preventing them. As to the argument regarding the resign to run position, it's an interesting argument, I guess. I think the legislature has made it clear as to whether it thinks that sheriffs should be campaigning in uniform. It had the opportunity to change that law in 2021. It chose not to change that law. So I think any argument along those lines, the state of the law is what it is. The ethics laws, the Ethics Commission's interpretation of that law has been clear. The outcome of cases has been clear, and AB 218 was an attempt to change that so sheriffs could campaign that way, and it didn't pass. So that's the status of the law. It is where it is. As to 400 subsection 2, this idea that the unwarranted advantage has to be a violation of some other law, that's just not correct. The unwarranted advantage, and this was first noted in Kirkland in 2014. It was noted in Ray Public Officer in 2020. The unwarranted advantage is giving the public and the voters the improper and incorrect impression that the subject is being endorsed by a government agency. By using government property to campaign, to support their private and pecuniary interest in a campaign, which is something that has been clearly found. Someone running for a campaign has a pecuniary interest in obtaining that position. Using your badge, your uniform is giving the public the impression that that subject is being endorsed by that government agency. Over and over again, as you heard me read from these, this commission talks about the power and prestige that the uniform and badge of a sheriff holds. And it is unwarranted because they hold a public office which is to be held for the people of Nevada, that they, as a individual running for an office, can use that government resource to bolster their campaign. That is the unwarranted advantage. And that has been held by this commission in multiple cases over multiple years, long before the complaint was filed. They also argue that the subject has a First Amendment right to advise the voters of his status as the duly elected sheriff, and that he has to have the right to combat negative ads. I don't disagree. However, he can't use government resources to do that. He has the right to do it. He has a First Amendment right to say, I am the sheriff of Clark County. He has a First Amendment right to say, here's all the amazing things I've done. He can say it as much as he wants. He can shout it from the rooftops. He is not allowed to use government property to say those things. And that was addressed by the United States Supreme Court in the Nevada Commission on Ethics versus Kerrigan, where it said, where a similar issue was brought up, where a legislator said when his vote was being abridged, that was abridging his First Amendment right. And the court said, that vote belongs to the public, not you. So you don't have a First Amendment right in it. Again, Sheriff Lombardo's badge and uniform do not belong to him. They belong to the people of Nevada. He does not have a First Amendment right to wear them. You can limit the use of public resources when they're being used for the personal reasons of a public officer. For that reason, this argument that a sheriff is disadvantaged because they can't wear their uniform, no public officer is allowed to use public property. We have numerous cases on this. You cannot use public property to run for public office. It's absolutely fundamental to the ethics laws. You cannot use public government property to run for office, and it's also very clear, and has been very clear from the beginning of all the Commission on Ethics cases on this, that sheriff's uniform and badges are government property. Then we look at 407. the issue of the unconstitutionality of the appearance of impropriety is discussed at length in both the briefs. First of all, again, already been addressed by the Nevada Supreme Court, already found that it's not unconstitutionally vague. You'll see that there's language and citations to that in our briefs and in Brave Public Officer 19-124C. And nonetheless, even if that subsection were found to be unconstitutional, that would only mean under Nevada law that the exception would be unconstitutional. NRS 400 subsection 7 would still apply, and we would still have violations here. There's the statement here that I noted. It said, the executive director never explains why a reasonable person would believe it was inappropriate for Sheriff Lombardo's campaign to depict him in uniform occasionally during the campaign. Just during the short time period between June 28th, when he announced his run, and I believe September, or when we gave our notice of the complaint, that was 68 times they posted pictures on social media. This is not occasional. This was it was pervasive. It was like the centerpiece of the campaign. So to say that this was some sort of occasional use that should be overlooked is disingenuous. And there's the argument again that the executive director's letter is a departure from the prior interpretation of 407 and eliminates the limited use safe harbor provision because we'd never there's a lot of things to address, I'm sorry. We'd never said what would be an appearance of impropriety. That goes all the way back to Kirkland. And in Kirkland, it's clear. The appearance of impropriety is a public officer taking public resources and using them to endorse another candidate, in that instance, which is equally applicable to endorsing themselves. Then in that case, it was the uniform, it was the badge, it was standing in front of the Washoe County Jail. It's using public resources to make it appear that an endorsement is being made by a governmental entity. And In re Kirkland has quite a bit of language that goes on to explain why it is never appropriate for a governmental agency to endorse a political candidate, and so why it is never appropriate for there ever to be an appearance that a government entity is endorsing a candidate. And that is what happens when government resources, government property owned by the people is used to bolster the campaign of one person. The previous precedent of this commission, the statutes are clear. Using government property in support of your personal campaign, which is what took place here, violates the ethics law. You cannot, it provides an unwarranted benefit in the sense that it imbues one of the candidates with the power and prestige of a law enforcement agency, when the other candidate does not have that, or any other candidate does not have that. And it benefits their pecuniary interest by allowing them the use of these government resources that are for the people and not for the personal use of someone campaigning for a higher office. The facts here show that that's exactly what happened. It doesn't, what kept being said is, oh, these 4 pictures, or this was over and over again, posting over and over again, different messages over maybe a same or similar picture, over and over, hammering home that the subject was wearing this uniform and this badge, which are government resources. This was not a small violation. This was not a small use of government resources. This was a very significant, knowing violation of very fundamental public ethics law, which is you cannot use public resources to support your personal campaign. We've gone through the willful factors, but I will say, I very much disagree with this argument that we're not treating the subject here comparably. There are no comparable cases. This is absolutely unprecedented number of violations. There is no comparable case. In the latest case, the Rodriguez case, we were talking about 2 unposed photographs that were posted to an About Me section of a campaign website. This was not a hundreds of times photos being posted to multiple social media platforms. You cannot compare, one video to the many times the same video was posted by the subject. This is an unprecedented case. Well, I disagree with the highest fine that opposing counsel found. I believe our highest fine is more in the 20,000s. Again, the statement that we've never fined anyone for this behavior, incorrect. We just, several months ago, imposed fines in Ray Rodriguez. Also, the explanation of why the in Ray Ramos does not apply in terms of the way we should be applying the number of violations misrepresents the facts and the stipulation there. There is an order in that case which found the 12 violations. The final stipulation actually resolved multiple ethics cases against Mr. Ramos, and so it has some specific language that refers to various different matters. But nonetheless, the conduct was failing to disclose a particular relationship, and that relationship was the ownership of a company by his sister. And this commission found that each time he failed to make that disclosure, that was an ethics violation. Not that just the failure to disclose that at any time was the ethics violation, but each time he stood in front of the county commission and failed to make that disclosure, it was a separate violation of the ethics law. That is analogous to this case. Each time a photograph, a posed photograph was posted showing the subject wearing public property in support of his campaign, that is a separate violation. Anything else would just gut the ethics law and be illogical. If this was one course of conduct, it would just mean that any subject could engage in like a huge course of conduct, as they would call it, and that has many violations in it, and it would be just one ethics violation. The application of the ethics law in that way would just make absolutely no sense, and would make it completely, and if this was one violation, why would anyone follow this law? If it's one violation, why would any candidate who's using public resources, and I don't just mean a sheriff in a uniform, but like of any case where you're using public resources to campaign, if the behavior is just one violation, then there is really no teeth to the law whatsoever, and there is really no deterrence to keep people from violating that very fundamental and important law. There's a lot of discussion about this being an unprecedented matter. It is an unprecedented matter. The fine, as I discussed, we've presented you with what is the maximum fine that is allowed under the ethics law. As discussed in the briefs, we're not limited to 3 violations. Again, that would not be logical in the scheme of the ethics law. It would mean there would be no deterrence for any subject to ever limit the number of ethics violations they engage in. We've presented what the maximum penalty is. It's up to this commission to determine what is the amount that will deter this conduct in the future. Clearly, what has been done in the past didn't deter this conduct. What will deter it in the future? What will deter this particular subject from doing it again? That is what should be considered. Like I said, there's no comparable cases here, and it's an unprecedented case that deserves an unprecedented fine. Thank you.
Thank you, Ms. Bassett. At this time, Mr. Williams, would you like to present any additional arguments or responses?
I'm going to try to be brief. You've been very patient with both of us, and you've had to sit through a lot. So let me just try and hit a few points that I haven't addressed, so I'm not repeating myself, and then I'll turn the microphone back over to the commissioners. With respect to the notion that I'm wrong that you have never imposed a fine, what I thought I argued was that you've never imposed a fine against a sheriff or an undersheriff. That was the point I was making. I hear a lot about these 5 stipulated agreements in the Kirkland opinion. My point is, in none of those did you ever find a violation of 400 subpart 2. In most of them, you didn't find a violation of 400 subpart 7. And in none of them did you ever impose a fine. Yes, in Rodriguez you did, like 3 months ago. That came after Sheriff Lombardo was already the subject of the complaint. So Rodriguez, yes, it's different, but it's not prior notice. It came after. And as far as it being a final opinion, I still can't find it on the website when we just looked, but maybe it's somewhere I'm not looking. The notion with respect to the stipulated agreements and that somehow I misrepresented the language in those, I don't think so. I mean, I'll just go to Kazanik. page 7, paragraph Q, this stipulated agreement is intended to apply to and resolve only this specific proceeding before the commission and is not intended to be applicable to or create any admission of liability for any other proceeding, including administrative, civil, or criminal regarding the subject. So yes, it doesn't require the subject to be bound by that in any other proceeding involving the subject, but it's broader than that. It doesn't apply to any other proceeding. Any means all. So I think I got that right when I said that they're limited to their own facts. With respect to the prior case, she keeps calling the prior cases the law. The law, the law, the law. Respectfully, I went through why we submit that is not precedent. I won't repeat it again. A lot was made about this proposed legislation, that the legislature could have changed the law regarding sheriffs if it wanted to, and it didn't. And therefore, that should be deemed to be legislative intent. Most respectfully, I don't think so. It never even came up for a vote. And I had the unfortunate opportunity to be on the opposite side of making that argument in a published opinion from the Nevada Supreme Court in 2023. It's called National Association of Mutual Insurance Companies, found at 524 Pacific 3rd, 470, 484, which says, unpassed bills as evidence of legislative intent have little value. So I don't think you can put a lot of stock in the unpassed legislation, particularly when it never even came up for a vote. The unwarranted advantage that we've heard so much about, and that it's, it's wearing the uniform, government property creates official sanction. Again, I can understand that argument better in the context of someone wearing the uniform that arguably could bolster that person's running for an office, like an incumbent sheriff who can portray themselves in the uniform of the office for which they're running, but not here when you're running for a different partisan office. We've covered that. With respect to Kerrigan, I'm not arguing that Governor Lombardo, then Sheriff Lombardo, was disadvantaged because he doesn't get to use government property. That's not my argument. My argument is that his opponents can portray him in that same government property and claim that it's a disadvantage, and under the executive director's position, Governor Lombardo or then Sheriff Lombardo couldn't respond in kind. That's what I'm saying. I'm not making an argument that was addressed in Kerrigan about a legislator's vote. And there's a blurring of the lines being done here subtly when the suggestion is made that Kerrigan, either at the U.S. Supreme Court level or at the Nevada Supreme Court level, addressed the appearance of impropriety standard. Let me be abundantly clear. It did not. And we pointed that out in the briefs, and they keep saying it, and it's wrong. It didn't. It addressed the vagueness issue as it related to the disclosure obligations that a public officer or an employee must have to make. Specifically, what does the language substantially similar mean when looking at the types of relationships that require such disclosure? Commissioners Olson and Moran made those types of disclosures today. That's what was being dealt with in Kerrigan, not the appearance of impropriety standard. What the Supreme Court did say that was telling is that the substantially similar standard was not vague because it was defined in part by the language that surrounded it. There were examples that were provided. And it said when those types of examples don't exist and when the standard is subjective, like we're dealing with an appearance of impropriety, that's what can create vagueness. That is our argument there. With respect to in re public officer, yes, there is a line in that opinion that says the Kerrigan cases addressed appearance of impropriety. Respectfully, that line is wrong in in re public officer. And all you need to do is just go read the cases. You don't take my word for it. Finally, this argument that there is no deterrence if the fines can only be capped at a third violation or at $40,000, I respectfully disagree. I mean, again, I didn't choose the language of the statute, but we're all stuck with it. It is what it is, and it's not ambiguous, and so you have to stick with the plain language. But there is deterrence. As we talked about, the legislature does recognize the potential for 3 or more violations, and there is a consequence. It's the strongest deterrence there is. You get removed from office, period. I think that covers everything I need to say. I thank the commission for its time.
Thank you, Mr. Williams. We've been sitting here for a couple hours, so we're going to take just like a 5-10-minute break, get back here by 12:30, right? And then we will start questions from
Very
the
good.
commissioners. Right, good afternoon. We'll go ahead and reconvene. At this point, I would like to ask my commissioners if they have any questions associated with this case. Fellow commissioners. Commissioner Yin.
Sharon, I have first a procedural question. So I have several questions based on starting from 400 subsection 2 down to penalties. Would you like me to just focus on one section at a time so other commissioners can ask the questions on 400 subsection 2, or just ask all of my questions at once?
I think I'd rather do section by section. I think that would make more sense. Okay, thank you.
Great. Okay. Thank you. Then I just have one question related to subsection 400 subsection 2 for Mr. Williams, for Governor Lombardo. Mr. Williams, you argued here today in your opposition to the motion for summary judgment, and I'm going to quote it. It was at page 7, lines 9 to 15. You said, but there's no evidence whatsoever that would suggest Governor Lombardo's use of the images had a cognizable impact on the results of the election, nor could there be, as Nevada's voters knew Governor Lombardo served as the Clark County Sheriff irrespective of any social media posts. There's no evidence to support a causal connection between the images and Governor Lombardo's salary and benefits in his current position. And you also argue that here today that the media and Clark County voters and the state of Nevada knew that he was the sheriff. So if that's Governor Lombardo's position, my question then is, what was the purpose of posting the images with the uniform and badge in the campaign materials, if not to obtain votes and influence the public?
Thank you, Commissioner Yen. Yeah, I think that's a fair question. I mean, I wasn't involved in the campaign, so I want to be a little careful that I don't want to reveal anything attorney-client in terms of discussions with Governor Lombardo. But I think I can certainly say that obviously the posting of the images was a willful act, no argument there. And I think posting them, obviously Governor Lombardo and his campaign hoped that they would be beneficial. I don't think there's any debate about that. But I don't know that it's the same thing to say that that willful act translates into a willful violation, which is what has to be found here. Again, you have to apply the facts to the language of the statute. And what it says is you've got to secure an unwarranted advantage. There's been no demonstration what the advantage is. I'm not denying that by posting them, the campaign or Governor Lombardo, then Sheriff Lombardo, thought it'd be beneficial. But I don't know that that means it's an unwarranted advantage or that it violated the limited use exception under 407. I know your question's only on 2, but I'll go ahead and make that point as well.
Thank you.
Sure.
Okay. Other commissioners' questions for council? Commissioner Lowry.
Thank you. I'm going to pose my question to both counsel. Mr. Williams, if you'd like to answer first, and then Ms. Bassett, if you have anything to add. So you've indicated that it would be fair to infer that the campaign thought that posting pictures of the sheriff in his uniform with his badge and the LVMPD material would be advantageous? Is that the word you use?
I said beneficial.
Beneficial, okay. Why can we not infer from that, if they did it because they thought it would be beneficial, they did it because they thought they would get votes, why can we not infer that that's an advantage?
Right, but is it, again, looking at the language of the statute, is it an unwarranted advantage? Is it unjustified or without adequate reason? Or did it, under the historical interpretation, did it violate a local law or code provision or something like that, which obviously it didn't. But I think there's a difference between hoping something will be beneficial in the eyes of the public versus saying that that constitutes an unwarranted advantage or a violation of another provision of the ethics laws. I don't think the two are synonymous. There's the Parrish case that's been cited in the paper somewhere, and it didn't involve sheriffs, it didn't involve uniforms, it dealt with a hospital administrator, I think, who had published a flyer for a board of trustee that was paid for with government funds. It was found to be a violation. And what the commission said is there's a difference between willful acts and willful violations. And I think that analogy applies here, or that concept applies here. I can't sit here and deny that the campaign posted the images. It did. I'm not in the mindset of what the campaign thought, but do I think I can say that they thought it'd be beneficial? Well, I think you wouldn't take me seriously if I said something differently. Of course it did. But did they think it was somehow, let's remember the context in which it was done. The law we submit, I know the executive director disagrees, is that the law hasn't changed in the area from Pitts when it wasn't deemed to be a violation of any kind. And I think, my argument would be that they believed it complied with the limited use exception. He wasn't like an Antonor. He didn't show up at 3 debates in his uniform. He didn't appear on a campaign float in his uniform. He didn't enlist members of the sheriff's office to show up in their uniforms at events. He didn't do some of the things that you see go on in these prior opinions, even though there was no finding of violation. This truly was, our position, a limited use that complied with the statute. And did we hope it would be beneficial? Yes. Did we think it was an unwarranted advantage under the language of the statute? No. I hope I've answered your question.
Thank you. Ms. Bassett, anything to add?
Sorry, I forget about the mic. I would disagree. I believe it's absolutely an unwarranted advantage, and the prior commission opinions have discussed and supported that language, that the a police officer's uniform, a police officer's badge, it projects a certain authority, it projects a certain governmental endorsement. That is an unwarranted advantage. It's not just an advantage, it's an unwarranted advantage because it is using a resource, a government resource, which that individual has no right to use to bolster that campaign. And as Mr. Williams has said, there's no question that the images were posted with the intent of helping the subject's campaign, and that use was unwarranted. And this idea that it's different than showing up at an event or a parade. I mean, number one, many of these old decisions existed long before Twitter. And so it couldn't have been addressed. And we have a literal parade of images being broadcast out every day to a huge audience on social media of the subject in his uniform, using these resources to benefit his campaign, and clearly using a government resource that gives the appearance of an endorsement, that gives an appearance that this law enforcement agency is backing this particular candidate is an unwarranted advantage.
Commissioner Lowry, can I follow up on that in addressing your question?
Sure.
Very quickly. What I said was that we hoped it would be beneficial, or the campaign hoped it would be beneficial. And the response is, well, it's government property, it's an advantage, the power and prestige of the office, et cetera, et cetera. But to who, right? I mean, I think that's an important question we're overlooking here. Undoubtedly, we hoped it would be beneficial with the public. But there are undoubtedly members of the public that do not look at the uniform and look at the badge and say, public trust, they're there to protect me. A lot of people feel the opposite way about law enforcement. So while we hoped it would be an overall benefit, there's certainly no guarantee that it would be, certainly an improper one. And in fact, a lot of people probably had the opposite view. So I would just add that.
Thank you. Thank you, Madam Chair.
Commissioner Olson.
Now, my question's for Ms. Bassett. And using your term about a parade of images, I think you said something like that. So, and it warranted, for lack of a better term, and this is not to be insulting, a stacking of the fines. I'm looking at the Ramos one, and using your term, a parade of 9 different county commission meetings, 17 documents. He was wrong, everything he did, and he got a $1,000 fine. There was no added on. Can you address that?
I can address that. It goes to what we've discussed earlier. In that matter, it was bifurcated between a hearing on whether a violation existed and whether a fine would be imposed. And in between those two times, the executive director and Mr. Ramos entered into a stipulated agreement that then went before the commission. And so the commission never made there was never a determination at the time of the violations what each violation would warrant in terms of a fine. We reached a settled agreement, like I discussed earlier, where Mr. Ramos at that time agreed to acknowledge that he had in fact violated the ethics law, which was something he had not been willing to do before. We settled multiple cases. So in that case, the fine, if you look at it, only applies to one violation. So the $1,000 was applied to one violation. And there was no fine determined for the remaining violations. Does that answer your question? Okay.
Yes, please.
But then based on that, if I understood, there was no discussion to add in the fines. Again, I'm trying to use the proper terminology here, to go the 1,000 to 1,500, whatever it is, because he entered into an agreement.
Right. We never argued that penalty was never argued before the commission. That would have been a separate commission meeting that never occurred.
So was there an agreement with Antonero?
I did not, I mean, in terms of the stipulated agreement?
Yeah, there was no fine, so, and I was aware of what Antonero did, and, you know, it's one of the big things you never do is tell your staff to get involved and bring in your uniform and be there. Yet that was apparently done. So I'm just curious as to why that didn't rise to the level of a fine, that regardless of the fact that Mr. Ramos entered into an agreement, it was only a $1,000 fine, and even though there were multiple offenses, and then we get to this one, I'm concerned that, and I believe Mr. Williams brought it up, was it because, or did it come about, or how can you calm me down about feeling it wasn't because he decided to dig his heels in?
I hope I made it clear at the beginning that what we are asking for is what the maximum fine that is allowed for under the statutes. That is what we're presenting here. Ultimately, it's up to the commission to determine what they think the fine should be. And oftentimes they deviate from what is exactly in the statute. I can only speak for me. I would request the same. It would have been requested in Mr. Ramos's case had there not been a stipulation in the meantime. It is not, I think as you've seen from the papers, because it was put into the record by my opposing counsel, there have been settlement offers for much less money in this matter as well. So it has nothing to do with that. The fact is we are here at a hearing. We're asking, we are presenting the maximum fine that is allowable under the statute for the commission to make a determination about what the deterrence is. It's not to penalize someone for going to a hearing. It is just like you would in any other type of matter. You're going to ask for, here is the upper limit of what you can fine.
Yeah, Commissioner Moran, then Commissioner Towler.
Oh, thank you, Madam Chair. So here's a couple things I'm having some problem with, and this is for both council actually, is I'm trying to get my head around this unwarranted advantage in this particular statute, because the way I'm looking at it is we have a statute, you know, then we take a look at whether or not it was willful. I mean, I'm past the willful part of this. And then the third item is what the amount of fine should be at that point in time. Once you have all three, all sevens, 777, they line up, you hit the jackpot. But in this case, I'm having a problem with number one. I'm trying to figure out how to line up that 7. I'm trying to understand an unwarranted advantage, because this is a sitting sheriff. That's his job. That's his job while he's campaigning for a different office. So can you help me understand what you, Ms. Bassett, what you believe to be an unwarranted advantage? Like, give me an example of an unwarranted advantage. I mean, I can see the advantage part. I just can't get to it being an unwarranted advantage. And on judicial review, I get a little nervous about that because I don't want to be a defendant in another lawsuit. So help me out with that.
I understand. First, speaking to your point that he is a sitting sheriff, he's going about his job, he's doing his work. Those are all facts. Those are all true. Were he to appear in the newspaper at a press conference, nobody is disputing that that is part of his job, and he's entitled to go to work in his uniform and do his job. The difference of what happened here is he went and had a professional photo shoot done in his uniform and badge. And then he took those pictures from that professional photo shoot and then used them in his campaign. So he took government property, used it in a professional photo shoot, and then used the pictures from that photo shoot to promote his candidacy, in which he has a pecuniary interest. So it's very different than someone going about their normal job and there having to be pictures, or they happen to be seen, or they end up, on the news. This is an extremely different circumstance than that. Unwarranted, it's unwarranted here because he had the advantage over candidates in the primary and then in the final race, or whatever you want to call it, of taking government resources and making it and using them to, as some of our president has said, clothe himself in the power and the prestige of that office. But those government resources don't belong to him. They belong to the people of Nevada. So he does not have a right to do that. He doesn't have a right to go to a post photo shoot. But
Ms. Bassett, let me understand this. I mean, we're agreeing that he's not moonlighting while he's the sheriff as a dancer for Cirque du Soleil. He's 24/7 the sheriff of Clark County, right? That's his identity.
Well, that's his job.
Right, and we're agreeing that it's a 24/7 job, right?
I don't know the parameters of his employ. I mean, I'm not aware of that being true or not true, to be honest.
Okay, Mr.
So
Williams, can you help
really
me understand
agree.
the unwarranted part of this and why you don't believe that it's an unwarranted advantage?
Sure. Let me see if I can help with the last point about what his job is or isn't. It is a stipulated fact, paragraph 2 on page 1 of the stipulated facts, that sheriff is the only uniformed public office in the state of Nevada. A sheriff is never, quote, off duty and must always be required to respond to a law enforcement emergency. I think that satisfies the definition of 24/7. What is not in the stipulated facts, at least from my review and my understanding of them, is that these photos were from a professional photo shoot. I don't see that in the stipulated facts, but I'll let Ms. Bassett address that. Unwarranted is defined as unjustified or without adequate reason. So that adjective modifies the advantage, but we have to go even earlier than that in the sentence, which is to say you have to have secured. Okay, it can't just be an advantage in the air, right? Like, I'm the sheriff, as I hope I made clear when responding to Commissioner Lowry, like, yes, there are probably some people that think wearing the uniform or that the uniform symbolizes power and prestige. Undoubtedly, there are people that think that. But I would submit equally undoubtedly, there are people that think the exact opposite. So what advantage have you secured? I would submit you'd have to point to there being people who voted for you, people who gave you campaign contributions, or people who did something else for you as a result. And let's keep in mind, not just that he's the sheriff, but from those 4 images. And so when we're talking about those 4 images, even if they were posted 34 times, not 68, 34, they get to 68 by double counting, that there is no unwarranted advantage based on the definition in the statute and also based on the historical interpretation that this commission has continued to apply even after the statutory definition, which is something's unwarranted if it violates the law. And clearly this doesn't.
Thank you, Madam Chair, and thank you, Council.
Okay, Ms. Bassett.
Thank you. Yeah, the stipulated fact number 12 is during the course of Lombardo's partisan political campaign, he created certain photographs and videos. I apologize, it does not say professional, but he did create them for the purposes of his campaign. They were not, as has been said in some other cases, historical photos that happened to be taken of him while he was doing his job that then were used. These were specifically created for the use in his campaign, and that is a stipulated fact. And I struggle with how to respond to this argument that some people might view him being sheriff as a negative. Certainly, Mr. Lombardo and his campaign advisors and the people involved in his campaign weighed that thought and determined that it weighed more in favor of running with a central theme of the fact that he is a sheriff of Clark County than the danger that there might be some people who don't like sheriffs. I think that's just an argument that doesn't go anywhere. I mean, to say like, well, it's okay that this person used a public resource because maybe some people don't like that, you know, the Parks Department. That's not a defense to a misuse of government property, that maybe some people might not have liked that government entity. Obviously, the use of the accoutrement of his sheriff's office was very purposeful. It was the very center of his campaign, and there was a reason for that. And it was certainly, under all the case law, under everything we've discussed today, it's an unwarranted benefit.
Commissioner Teller.
Thank you. For Mr. Williams, we talked a lot about, or a little bit about, the 24/7 nature of the sheriff's job. I'm trying to reconcile that with any limitations you might see on campaigning as the sheriff. If you'd mentioned, I think, the Hatch Act, and you wouldn't be able to, the then Sheriff Lombardo wouldn't be able to go door to door and knock on doors and show up all the time with the badge and the uniform, right? And if so, if you do agree with that, where would we place that line? Where is that limitation? Are we limited to the Hatch Act that, as you said, doesn't necessarily apply to us?
Sure. Very, very good question, and I'll start where you ended. No, I can't sit here and tell you that the Hatch Act imposes limitations on this body. It doesn't. Like, that's clear. But what I have argued and what I would re-argue is that I do think the way the Hatch Act addresses the issue is certainly persuasive, and it helps address the vagueness argument, right, when we're engaging in a line drawing exercise. Because let me re-emphasize, like, you're stuck with the statutory language the same way I am, the same way the executive director and his counsel are. We didn't draft it. Okay, we can only deal with what we have. And so when we're talking about an appearance of impropriety, it is totally subjective. What one person thinks may appear to be improper, another person may not. That's what creates the problem here. But what I like about the Hatch Act opinions and what I think would help offset that danger is it does provide examples of what would constitute an appearance of impropriety. Unlike 400 subsection 7, which has no examples, the Hatch Act opinion does talk about canvassing. Law enforcement officer knocks on your door, you're going to answer it because you think the police is here. You don't know if it's because, you know, something has gone on in the neighborhood, someone in your family hopefully hasn't done something wrong, someone's been hurt. You don't know, so you're going to answer that door. When the law enforcement officer then says, we'd really like you to vote for whether it's me or my boss or whoever it is, that is improper because it's coercive, right? And that I think is an easy one when you talk about something that is clearly crossing the line in a uniform. You can't do that. The other examples I mentioned would be, and I don't know that you need a uniform for this, but, you know, to offer leniency. Theoretically, if you had someone, you know, sitting in a cell or an interview room that had allegedly done something wrong, and the detective or the law enforcement officer sitting across the table and says, you know what, we could make this go away. You know, we'd like to see you vote for the sheriff, or we'd like to see you make a campaign contribution, or we'd like to see you get out there and post signs. Clearly a violation. Asking your undersheriff or people in your office, your staff, you know what, it'd be great to see you on Saturday at the picnic when I'm raising money or doing whatever. And you know what, wear your uniform. That would be helpful. You can't do that. Those types of examples, I think, help define what appearance of impropriety means. But when it's just sitting there in the abstract and we're forced to all guess at what it means because it's truly subjective, that's where the problem arises. And so that's how I think the Hatch Act's opinions should be viewed as being persuasive, but they're certainly not binding on you.
Thank you. I'll give Ms. Bassett a chance to respond to that if you do, but also kind of a follow-up to what you said. You responded to the ad by then Governor Sisolak that was kind of, you know, bringing down or trying to use the position of sheriff against then Sheriff Lombardo. And I believe you said then Sheriff Lombardo would be able to defend his position as being sheriff. What limitations would we be able to allow? You know, because obviously we're saying you can't use your badge and your uniform. What factors do we have, or how far can he go in defending his position as being sheriff, as being someone who is, you know, in a position to be governor?
Right. The subject would be entitled to say anything in response. He's entitled to counter that ad with statistics, with an ad that counters it in any way, except for using government property. I mean, the line is, you can't use government property, and uniform and badges are government property. That is the line as it exists. He could give interviews. He could do anything you want. I mean, anything you want. Talk about your what you've done. Talk about your experience. You have a right to all those things. You have a right to talk about your background. You have a right to talk about your experience. You have a right to talk about the position you hold. You don't have a right to use government resources in a campaign. And in response to the appearance of impropriety, you know, that was established in opinions by this commission back in 2014 in Kirkland. It's been the law for a long time. There isn't any vagueness as to whether this commission considers it to be an appearance of impropriety. We've written it. It's a hard line. You know, I don't think this idea that it's vague, and how would we know what it is or isn't in this context? There's no vagueness. It's been in our opinion since 2014. Actually, 1999. I have Kirkland wrong. I'm sorry. So it's been in our opinion since 1999. I mean, you know, when any current sheriff or other law enforcement officer is looking at whether this exception is going to apply to them, there's no vagueness and there's no confusion. It's already been interpreted by this commission to be to have an appearance of impropriety.
Commissioner Towler? Or do I ask Chair Wallen if I can respond? No, you don't. Okay, I apologize. Very quickly, I just wanted to clarify. The example that I gave with respect to the campaign ads, let me clarify it because I think something's getting lost in the translation, and it's probably my fault. The example that I proposed is if Governor Sisolak, at the time, it could be any opponent, I don't mean to single him out, took footage from a press conference that Sheriff Lombardo gave, not because he's using the images for campaign purposes or political purposes. He's giving a press conference, and he makes certain statements at that press conference. He's not using the public's property, for a political purpose. He's doing his job. And the opponent then takes footage from that press conference, turns it into a campaign ad, slices it, dices it, and conveys arguably a message that was not made during the press conference to suit a campaign purpose. Under the executive director's interpretation, Sheriff Lombardo, not because I'm going to dress up in my uniform and respond, he couldn't take footage from that same press conference in his uniform, in his badge, and say, here's what I really said. I didn't say the way they manipulated it in the ad. This is what I said. That would be prohibited. That is what I say is inherently unfair and doesn't serve the important purposes of the ethics statutes.
Do you want to respond?
Yeah, the response is, those are not the facts that are before us today. The facts are, we've stipulated to the use that was actually done, the use of the pictures that was actually the facts in this case. That's what we're looking at. This hypothetical situation that did not occur is not before you today and is not the basis for any of the violations, penalties, or anything else I'm asking for, so it's really not relevant to what I'm asking for.
Except there's a hard line. We've heard that over and over and over. So whether it's hypothetical or not, it'd be a violation.
Well, I appreciate both of your answers, your responses. Thank you.
Commissioner Lowry?
Thank you. I think I have another question that I want to put in here because I think it's in the arena that we're talking about. Mr. Williams, you talked about the sheriff being required to wear a uniform. Is that requirement under the NRS, under case law, under policy? Is he required to wear his uniform and the accoutrements of his office every single day?
I've learned doing enough appellate work to tell you when I don't have a definitive answer to a question. What I was reading from was the stipulated fact. So I don't know what the source of the obligation is, if it's metro policy, if it's state policy, or I'm not sure where that obligation comes from.
So, because in my memory, many sheriffs often wear civilian clothes, that they're not required to wear the uniform and the accoutrements of the office every single day. I believe under either their policies or maybe the statute, there are very specific instances that require them to be in uniform. But arguably, they might choose to go to the office 80% of the time in a pair of slacks, a blazer, a dress shirt, and you're not going to see their badge, you're not going to see their gun, and they're going to look like, a civilian. You wouldn't know otherwise. So I was left with the impression that somewhere there was a legal support for the fact that he had to wear his uniform every day.
Right. I think, and let me clarify my position then. What I had read in response to Commissioner Moran's question, the stipulated fact about always being on duty. And so when I analogized it to 24/7, that's what I meant. I don't think that the Sheriff Lombardo or any sheriff has to be in his or her uniform 24 hours a day, 7 days a week. But I do think they always have to be prepared to respond to a law enforcement emergency. And when they do, they've got to take their badge and they've got to take their gun. And so that I do think is a requirement of the office. And there are, in fact, I think in the record even, there are some of the alleged violative photos reflect Sheriff Lombardo in a dress shirt and in his slacks, but you see his badge. It's on his belt, I think. and carrying his firearm. The firearm isn't an issue, that's his property. I don't think that's been the focus here. But you're absolutely right, and to the extent that my arguments have conveyed that the sheriff has to be in his uniform 24/7 as opposed to being required to respond to an emergency, that's a fair distinction.
Chair Wallen?
I see
Yes,
Commissioner Yen has a
Commissioner Yen,
question.
yes, please.
Thank you. I'm along the lines of the appearance of impropriety as well. And this question is for Ms. Bassett. You've stated there's a hardline rule that you cannot wear your uniform and badge in campaign materials, and it would automatically create an appearance of impropriety. With that hardline rule, can you talk about what the effect that would be on the limited use exception, and would that essentially nullify the language in the statute? For sheriffs, for uniform and badges specifically.
I'm so sorry. Could you say that one more time? I couldn't hear the whole question.
Oh, my apologies. So you've stated it's a hardline rule that sheriffs, police officers cannot wear their uniform and badge in campaign materials. This has been a bright line rule essentially that the commission has made. What effect does that have on the limited use exception contained in the statute for 400 subsection 7? Does that nullify the limited use exception?
I don't believe that I don't believe it nullifies it now. I believe that what the commission did in Kirkland was look at this issue and make a determination that a public officer using their uniform and badge creates an appearance of impropriety. That's a finding. Like the finding was that is that creates an appearance of impropriety. So I think it's just that a determination has been made that factor 4 of that exception is not met where uniform and badge are being used in support of a campaign. I don't think it nullifies it. I just think that is a finding that has been made. It's a precedent, much like in a case, courts make rulings like that all the time that then are applied in other cases.
Hang on,
If I may briefly respond to Commissioner Yen's question, I think it's an important one, and certainly one of the important arguments we've made. With all due respect, the problem isn't Kirkland. Kirkland was decided in 1999, and it did make this finding in that case that using a uniform in an endorsement, it was the factual setting there, it was then District Court Judge Hardesty, could constitute an appearance of impropriety. Again, no violation, no fine. But the problem arises with the sheriff's letter. It's not even so much a problem with Antonoro when the commission changed positions from Pitts. The problem is with the sheriff's letter, because that's what takes 400 subpart 7 and the limited use exception and wipes it out, because it extends the prohibition to any campaign. Commissioner Yen, I know you do appellate work like I do. When there are provisions of a statute, they have to mean something. They're not to be interpreted in a way that render them superfluous. Otherwise, why would they be there? You don't need them. The limited use exception has to mean something. There has to be a safe harbor for public officers and employees to engage in limited use of government property. And we submit that's what was done here. But the interpretation from the executive director's letter does, in fact, nullify the safe harbor provision in our view. And a final point on that, the argument was made earlier that, well, if the appearance of impropriety prong is found vague and ambiguous, then all that happens is the limited use exception goes away. But I don't think that can be the result here. The limited use exception has 4 prongs. I don't know why prongs 1, 2, and 3 would have to go away if 4 went away and leave just the prohibition in place. That doesn't make any sense when the legislature clearly intended for there to be a safe harbor for officers and employees of the state. Thank you.
Just a follow-up question, Mr. Williams, then, and for 400 subsection 7, it's a conjunction though for the limited use exception, right?
You're right, it is. The word "and" does appear there. But
So it's your position that with it being conjunctive, that if you get rid of subsection 4, 1, 2, and 3 would have to stay even though it's a 4-part?
so my position is twofold, frankly, is if the argument is going to be that the limited use exception goes away because, for example, under your reasoning, it's conjunctive and means that they all, either you need them all or it doesn't matter. If you don't have one, you don't get the exception. If that is going to be the finding, if appearance of impropriety is unconstitutional, then my position would be that subsection 7 in its entirety would have to go away because the legislature intended for there to be a safe harbor when it uses the language, a limited use of government property, equipment, or other facility for personal purposes is not a violation. Like, that has to mean something. So it's either all of subpart 7 goes away or just subpart 4 of 7A. And I know that's kind of confusing gibberish, but we're talking about the provisions of the statute here.
Yeah, I followed. Thank you so much. My final question then is to you about the appearance of impropriety. So you have argued that it's constitutionally vague, and that's generally a determination made by our courts. Do you have authority that says that the Ethics Commission can make such a determination that a statutory language is vague and ambiguous?
I don't have authority saying that you can or you can't do it. That's certainly our argument, and I don't want, as trying to be a good lawyer, we've made all the arguments we think legitimately apply. Whether you rule on that specific issue or make a finding or disagree with me, I just wanted that argument to be in the record in the event. Hopefully it's something we don't have to do, but if we needed to seek judicial review, I just wanted to make sure that we had preserved that issue going up.
I understand. Thank you.
Commissioner Olson?
Yeah, my question was covered by Commissioner Yen.
Can I
Ms.
quickly
Bassett?
respond?
Yes, you may.
Just a few clarifications. Mr. Williams noted that there was no fine and no finding of a violation at Kirkland. Kirkland was an advisory opinion. There are no fines, there are no violations. That is where, of course, a public officer or employee can ask this commission whether certain behavior would be a violation of the ethics law or not, or how to avoid such violations. You know, this issue of whether or not subsection 4 of the 407 A is superfluous. It is not. We apply it in numerous other instances outside of, this is not something that gets applied only in uniform and badge cases. This is a test that gets applied when government resources are being used by public employees and officers in various different ways to determine whether that use is an actual violation of the ethics law or not. It's not just uniforms and badges. We apply that subsection all the time, and there are many cases where it has been found that where that fourth prong has been found that there isn't an appearance of impropriety, and so at no point is it superfluous. And I would disagree that if subsection 4 went away, the entirety of subsections 400 subsection 7 would have to go away, because under Nevada law, NRS 0.020, it's very clear that if one portion of a statute is found to be unconstitutional, we limit that impact as much as possible. So it says, such invalidity shall not affect the provisions or application of NRS, which can be given effect without the invalid provision or application. And to this end, the provisions of NRS are declared to be severable. So clearly, the what Mr. Williams is calling safe harbor provision is severable from the rest of NRS 407.
Mr. Williams.
The same argument could be made regarding
Okay.
subpart 4 of count of 1, 2, 3, and 4, but I'll leave it at that.
Thank you. I'm going to ask a question. It's my turn. I just have you mentioned, Ms. Bassett, earlier you mentioned, and when I was looking through the materials, that the appearances, the ads and the pictures and stuff only went up through September of 2021. And I thought you mentioned that it was going on after that. Do you know how much it went on after that, and why did we not include the rest of those things in your findings?
Thank you. I couldn't give you an exact number because we didn't look beyond that date. That is a jurisdiction that we have in this matter, because that is when we provided notice to the subject of this ethics matters, and that's how our jurisdiction works. We look only backwards from that date, not forward. Certainly, the election wasn't until November of 2022, so an entire year later. I know from my own review of the social media, yes, there was many more instances of the use of the photographs and the uniform and the badge, but we are limiting our action here to just that jurisdictional time from backwards from when the notice of the complaints was provided to the subject.
Then I have another question for you. So my understanding, if in order for us to find a violation of NRS 281A 402, do we also have to agree that the use of a badge and uniform and campaign materials equates to using the subject's position in government to secure an advantage?
I'm answering your question but the issue is the way that, for purposes of 400 subsection 2, the way the subject used his position in government to grant an unwarranted advantage to himself was the use of the uniform and the badge. Is that what you're asking? Okay. I'm sorry. Right. So the subject's position as a public officer gave him access. Hopefully, I'm answering your question. Gave him access to the items we're discussing, the uniform and the badge. So in his public position, he had access to those items that he then used to secure the unwarranted advantages that we're discussing.
And just one final thing. In a lot of the materials that I've been reading through, it just talks about, it almost implies that this law just applies to law enforcement. My understanding is correct. This law applies to all uniformed public officers and employees in Nevada, in the cities and counties. Is that correct?
That is correct. For instance, Ray Cochran was a fire chief. It also applies to non-uniform. I mean, use of public resources applies to non-uniformed public employees and officers as well, of course. Specifically, uniforms and badges applies to not just law enforcement, but any position that, uses a uniform and badge. So we have had cases with fire personnel. We've had cases with fire marshal, inspectors. I mean, so this is not just law enforcement. This is uniformed positions.
Commissioner Moran.
And thank you again, Madam Chair. So I know we're kind of skipping around. We're going from subsection 2 to subsection 7 and then back to subsection 2. And I just, again, I think we know where we are on subsection 2, at least I do in my mind. But I want to, and that was my first line of questioning. I would like to kind of skip to now subsection 7 and not attack it, but try to figure out where there is this preponderance of evidence that would find liability on that particular statute. And that's before getting to willfulness and whether or not the amount is correct or reasonable. So here's a couple things I'm dealing with. Again, let's stay focused on 400 subsection 7. And again, getting into this limited use exception. We're all on the same page that 1, 2, and 3, we agree on 1, 2, and 3 that there is not an issue with 1, 2, and 3. We're looking at the appearance of impropriety in 4, right? Okay, so it looks like, and again, this isn't my first rodeo. I mean, I was the chair of this commission at one point in time. It may have been like 100 years ago, maybe not that long. But from what I can remember, the commission has historically relied on the legal definition of the appearance of impropriety. And they've relied on the Black's Law Dictionary definition of this particular wording or characterization. And is that a correct statement? Is it correct to suggest that the commission has relied on the Black's Law Dictionary definition of appearance of impropriety?
It quoted that in Ray Public Officer 19-124C. I can agree, yes.
Okay. So the follow-up question to that is, and this is kind of following up on Commissioner Yen's comments regarding the appearance of impropriety. Now, I think we know as practicing lawyers that the rules of professional conduct have taken out the appearance of impropriety because of it being vague and ambiguous. Would we agree on that as well? That our rules governing the conduct of lawyers and lawyer misconduct has taken out the appearance of impropriety as being vague and ambiguous? Did you know that? Mr. Williams, would you agree with that?
I would agree. We cited 2 cases in that context standing for those propositions, yes.
And then would we also agree that currently the Nevada Code of Judicial Conduct has not taken that phrase out, but there has been a referral again that the removal from the RPC because that standard was ambiguous. It was an ambiguous standard and had long been abandoned. And there's some case law here that I'm looking at in Nevada that has talked about that standard being abandoned, that appearance of impropriety. And then it goes on further in the Nevada Code of Judicial Conduct states that it retained a phrase, quote unquote, judicial discipline will not be premised upon appearance of impropriety alone, but must also involve the violation of another portion of the code as well. So, Ms. Bassett, would you agree that that's a correct statement of the Nevada Code of Judicial Conduct, or do you not know?
I will not dispute that I assume you are quoting it directly. I do not have it in front of me at the moment, so I can't.
So the issue for me now with those statements is that it seems as though the appearance of impropriety as a standard doesn't, even in the Nevada Code of Judicial Conduct, provide a mechanism for discipline or liability. So do you kind of see where I'm going with that in terms of it being vague and ambiguous? And if it is vague and ambiguous or not, it's still, the appearance of impropriety does not provide a means for discipline or liability. Now, let me go one step further than that, too. The appearance of impropriety language And I have a case here, Flamingo Paradise Gaming LLC versus Chanos. This is a Nevada Supreme Court case in 2009. It says, the appearance of impropriety language unconstitutionally vague or so standardless that it authorizes or encourages seriously discriminatory enforcement. And then it provides for the severance doctrine, which we talked about a little bit earlier, that the remaining statute should be upheld where it, and this is quote unquote in Flamingo Paradise Gaming LLC versus Chanos, 125 Nevada 502, this is a 2009 case, that the remaining statute should be upheld, quote unquote, where it is possible to strike only the unconstitutional portions. And it seems as though they state to a two-part test that provides this statute is severable if the remaining portion, standing alone, can be given legal effect, and if the legislature intended for the remainder to stay in effect when the unconstitutional part is severed. So what I'm looking at here is if we're in agreement on 1, 2, and 3, authorized by an established policy, the use does not interfere with the public officer's performance of public duties, the use has a nominal cost, and then we get to this, the use does not create an appearance of impropriety under 281A 407 sub A. I'm trying to understand that, do you believe that that line of questioning and that dicta that has been delivered by our Supreme Court would not be of some precedential value in determining whether or not this appearance of impropriety standard is actually vague and ambiguous? Part one. And then part two, of course, would you also agree that this statute should be severed? We apply 1, 2, and 3, 4 goes away, and there's just not a preponderance of evidence currently before this tribunal to make a determination on summary judgment as to why he has or has not violated that particular subsection of that statute.
Okay, thank you. First of all, I think we're talking about two different statutory frameworks. So the way that the Supreme Court in Flamingo Paradise looked at that particular phrase and how it is used in that statute would have to be analyzed in comparison to the overall statutory framework in comparison to ours. But I'd like to kind of talk about this idea. The concern there is discriminatory application, correct? I mean, that was the entire kind of crux, as I understand it, from the Supreme Court's concern was that it was open to discriminatory application. There is no discriminatory application in this case, or in any of the uniform cases. It has been, for lack of a better word, uniformly applied in every case the same. There was a decision made in 1999. It has not been applied in some and not others. There's an appearance of impropriety when you wear your uniform, but not your badge, but your gun, but maybe not this. It has been clarified, starting with Kirkland in 1999, that it's not an appearance of impropriety if you use your name, your title, you discuss your background, but it does create an appearance of impropriety if in the course of endorsing a person's candidacy, that you use the physical accoutrement of office or position to bolster the endorsement. In this case, of course, the subject was endorsing himself. And so there is no discriminatory application here. I can see we're in the context of judicial ethics. What constitutes an appearance of impropriety may be a very different consideration. There might be a lot more things that go into it than whether there is an appearance of impropriety under the facts as we're discussing them today.
But Ms. Bassett, would you agree that the appearance of impropriety does not provide a means for discipline or liability under that specific statute? This is sub 7 again, not subs 2.
It does not provide a means for?
It doesn't provide a mean for discipline or liability. Meaning to, quote unquote, find that there is an appearance of impropriety or that a public officer has committed an act of, or has engaged in conduct that would be considered an appearance of impropriety do you believe that there's discipline or liability that should attach when that public officer engages in that type of behavior?
I think the discipline attaches when you use the public resources in support of your private or pecuniary interest. This is a provision that may relieve you of that obligation if certain circumstances are present, which from the way you've read it, I'm going to make a leap that it's used very differently in the Judicial Code of Ethics. Here, there is a violation, and then you may be relieved of that violation if these four things are present. It's not that there is a appearance of impropriety and that creates the violation. Now, the issue here is you have used a government resource, that is an ethics violation. Now, under these four circumstances, you may be relieved of that if these four things are present.
Okay, and do you believe that the commission has the ability to determine language unconstitutionally vague, such as the appearance of impropriety? It seems like there's been cases that have actually discussed that particular principle.
Of finding it I don't believe that it is unconstitutionally vague, no. I believe that it's been addressed in Supreme Court cases. I believe that it is not being applied in a way that is discriminatory. I don't believe the same factors that were present in those matters are present here in this statutory scheme work or in the cases that have applied it.
Okay, so so last question, and then I'll wrap it up. So if you felt that the appearance of impropriety, the standard, was vague and ambiguous, would you agree that we go to a severance and that the statute without that number 4 provision would provide exculpation of the current governor as a result of that finding?
I do not. I believe it would get rid of the entire, all four, because I believe the 4 factors have to be there together. And so I believe if you find that vague, they all go, and there is no,
So under
we
that,
just have 407 without the exception.
okay, so but under that theory, though, we would still be finding no liability.
No, we would be finding liability.
So if you're saying if the severance means the statute goes, then there wouldn't be liability under the statute?
No, only the exception to the statute would go.
Oh, the limited use aspect
Correct.
of the statute. Okay, very well. Point well made. Mr. Williams, do you have any follow-up on that?
Probably none that wouldn't just completely annoy the commission at this point. But, I mean, I'm happy to walk through it, but I think my position's been pretty clear on it. And I think you've accurately articulated the point that appearance of impropriety was taken out of the professional code of conduct relating to lawyers because it's absolutely vague and ambiguous. And as it relates to judges, it's still there, but a judge can't be disciplined solely based on the appearance of impropriety. There's got to be another tangible violation. And if we want to analogize that to this situation, all they're saying is that there's an appearance of impropriety here, so you don't get the benefit of the limited use exception. And the final point I'll make is that the statute doesn't operate the way Ms. Bassett just articulated. It's not like you've used government property, you have violated, let's see if you get out of it. What the language of the statute specifically says when we start talking about that is this subsection does not prohibit. Does not prohibit. So it's not like you have violated it, let's see if you can escape the violation. It specifically says if you meet these 4 things, it's not a violation, period. That's all I've got.
No, thank you both. Thank you, Madam Chair.
All right, fellow commissioners, I don't see any further.
Chair Wallen?
Yes, Commissioner Yin. Oh, that's right, we still
Yes.
have the willfulness.
We still have willfulness and penalties.
Right. Please proceed.
Thank you, Chair Wallen. I just have one question for Mr. Williams related to the willfulness and specifically just so that you know which subsection of the statute I'm looking at, which is subsection D to 281A.775. And it's just after receipt of the first complaint in September, I'm just curious as to why the photos and videos were not removed, even out of abundance of caution, similar to, and I call it Kuzanek. I don't know how it's pronounced, but in that matter, he didn't concede a violation. but he was working with the commission and he removed the the photos with the uniform and badge. So I'm curious as to why now Governor Lombardo did not do the same.
Yes, a fair question, and I'm sure it's me that's pronouncing the name wrong, so I would tend to think you've got the pronunciation correct. But that is a fair question. It's one I've thought about, and I frankly expected to be asked. So, and again, without revealing anything attorney-client, I think what I would tell you is that the simplest answer is that no one came to Governor Lombardo, then Sheriff Lombardo, and said, hey, these complaints have been, or someone's raised this issue, they're thinking about filing a complaint against you. What happened procedurally, I think this isn't disputed in the record, is the Nevada Independent issued an article in the summer of 2021 wherein it talked to the then executive director of the commission and asked some questions about this. And frankly, the article, I thought, did a good job of identifying the ambiguous nature of the issue and asked the executive director to comment on it. And the next thing that happened was in, I believe it was September of 2021, is when the executive director just filed his complaint against Governor Lombardo. So there was no, hey, this may be an issue, we'd like you to take these down, nothing like that. There was one complaint filed in September, then there was a second complaint filed in October, and I won't get into the issues surrounding like how those complaints were generated and who they were by, but that was the sequence of them. And so at that point, Governor Lombardo's position was, if I take them down, it's going to be viewed as a tacit admission. And there was no dialogue with respect to, well, you can take them down without being viewed as a violation or a tacit admission. It was just, here are 2 complaints against you, you get a chance to respond. That was the end of it. And I would probably be remiss in saying that at the time, Governor Lombardo and his team didn't think it was a violation. That's sort of our whole argument, right? That because of the Pitt's opinion, because the law hadn't changed, because of the fact that what Governor Lombardo was doing or Sheriff Lombardo was doing was different than every prior opinion, at least in our view, that he wasn't doing anything wrong, and he didn't think that then, and his campaign didn't think it then, and most respectfully to this body, we don't think there was anything wrong with it as we sit here today. And so that would be my best answer to that question, Commissioner.
Okay, thank you. And I'm sure my fellow commissioners might have other questions on the willfulness, but I just have one question on penalty, and I just want to go ahead and ask it. So you discussed at length the civil penalties, but if we do find any violation, what is Governor Lombardo's position on a censure and an ethics officer in the governor's office?
Right. So the censure is there's 3, right? That are 3 possibilities. There can be an admonishment, there can be a reprimand, there can be a censure. The censure is the one that connotes the most negative message from this body, right? It's finding that there was a willful violation that was accompanied by, and I don't have the language in front of me, but it's something like bad faith and malice and a bunch of these other states of mind, which, how you've proved that, I don't think that's been done by a preponderance of the evidence. So clearly, we completely disagree with the notion of a censure. An admonishment, my understanding in reading the statute, is that can be in a situation where there's not a finding of a willful violation, but it's nonetheless a message of, hey, you may want to pay attention to what you're doing. And then you have a reprimand, which is, I think, a willful violation, but it's not accompanied by those other mindsets that justify a censure. Respectfully, I don't think any of them are appropriate, and I'd probably just go back to my preceding answer that, we didn't think then, or the campaign didn't think then, and most respectfully, we don't think now that then Sheriff Lombardo engaged in any violation of the ethics statute. So I don't think it's appropriate. And frankly, that's one of the reasons why I didn't get into this, but it was raised by my colleague that, we treat stipulated settlements differently than people who want to challenge the threshold notion of a violation. And I don't think that's proper. That may be the practice, but I think that results in an anomalous situation where, someone subjects themselves to stricter or harsher penalties just because they want to challenge what they think is an erroneous charge. But there was some settlement dialogue with the parties. And the settlement dialogue, Commissioner Yen, and it's Exhibit 37, which, again, has been admitted not for the purpose of showing liability or anything, but to sort of show what we contend to be overreach or bias. And it was this. It was, you've got to admit to 3 willful violations, and you have to pay $50,000, which, A, we contend exceeds the statutory limit, but B, it's still, what, 3 times higher than the highest fine this commission has ever imposed? And there had to be a censure, and there had to be an ethics training. We don't have a problem with the ethics training. I think you heard Executive Director's Counsel acknowledge that in his capacity as governor, he has welcomed ethics training and he has participated in ethics training. So no problem on that one. But a censure, we don't think that's appropriate, and we certainly don't think a fine or any willful violation is appropriate either. And happy to answer anything else you may have on that.
That's it. Thank you.
Other questions about willfulness or fines for council? All right. Well, with that, then we will go into closed session to deliberate, and I think we have your phone numbers so we can text you when we're coming
Okay,
back. So
great. Well, we won't go far. So.
okay, yeah. All right.
Thank you very much.
Thank you.